Justice, where are you? Michael and Linda are here.
Love you, Linda.
The world is justice. Will we ever find justice?
The courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be and Damila lead the way. Hoping justice will win the day. Listener clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
All right. Does that moot every issue that I researched last night?
I apologize, Judge.
No, I just, every issue with regard to the. All right, at the close of yesterday's day, the defense raised with me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today?
No.
You do not? All right. Does that moot every issue that I researched last night?
I apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is to defense intend to call any other witnesses.
You're not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day. Let me just put in the record, so the record is complete. The Commonwealth previously, and I ruled on this at the side of the bench previously, the Commonwealth previously asked this court to exclude the defendant's plea of guilty. And I guess the only way that would come in at this point is if he were testifying. But I just want to put in, to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously, I want to put in the reason why I excluded that testimony now. The Commonwealth did file a motion in limine to exclude evidence that the defendant pled guilty to misleading the police into Anna Walsh's disappearance and improper disposal of her body. After consideration, I allowed and still am allowing the Commonwealth's motion for 2 reasons. First, the defendant has failed to show how such evidence is relevant to the remaining charge of murder. And I specifically acknowledge that I read this morning the defense's motion to admit the evidence of his guilty plea, which has been docketed as 216. That was filed on December 11th, 2025, this morning, I believe. I have read it, but it doesn't do anything more than to set forth the elements of the crimes of murder. Based on defense counsel's opening statement, it appeared that the defendant was going to testify in this trial. And at that time, he could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the 2 charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge. As explained by the SJC in Commonwealth versus A Juvenile, 396 Mass 108, 112, it's well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this. Continuing with this case, the role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez 70 Mass Appellate Court, 699-701-2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding in a juvenile applies with equal force. If the defendant, a defense was permitted to tell the jury that he pled guilty to the two lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge. Indeed, the defendant has not offered any other rationale for the entrance of such evidence. And as was stated in Commonwealth versus Ferreira, 373 Mass and 24, 1977 case, the jury's function is not to weigh possible verdicts with an eye towards dispensing mercy in certain cases or imposing heavier penalties in others. Rather, the jury's function is solely one of fact-finding with respect to the legal standards regarding innocence or guilt. Accordingly, the defendant is not permitted and has not been permitted to put evidence before the jury of his prior guilty pleas in this matter. And Madam Clerk alerted me to also file this morning 321, pause, the Commonwealth supplemental motion eliminate to exclude evidence of the November 2025 guilty plea, which I will concede I did not read because I just got it when I stepped on the bench, but I'm not sure it makes a difference in light of my ruling.
Moot at this time, Your Honor. Thank you.
All right, is 216 something you filed earlier? Why does it have this number?
No, that's my error, Judge. That's my error. I corrected it on the original. It should be 318. It's my poor vision.
Okay. So just so the record's clear, when I said a moment ago, I did review what the defendant filed this morning. It's just not 216, it's 318. All right. On the docket. All right, I see that I have two other pleadings up here, which I will address in brief. One of them I was going to address anyway. It's in substance, maybe not exactly as it's presented. Those are items number 319 and 320. Let me talk about 319. I haven't read it either. It's a motion to prevent the Commonwealth from basically, I believe, an Attorney Tipton, you can, or Porges, you can illuminate me greater, but you don't want them saying he promised you something in the opening statement that he didn't deliver.
That's right, and after consulting with the Commonwealth this morning, they have no intention, they've told us they have no intention of doing that.
So I have already pulled out some case law on this and where the boundaries are, and I was going to give it to you in the charge conference anyway to make sure that you were aware where the boundaries are. The SJC has spoken on this issue of what's permissible and what isn't. The Commonwealth is allowed to get into it a little bit. I will alert you to those cases, and that's where I intend to draw the line as to what's permissible. I probably have them on my bench right now, but I couldn't tell you where they are. But when we get to the charge conference, I'll give those to you so you both have the benefit of my research on that issue. The other motion, 320, is I expect the defense will renew after I bring in the jury, ask you if you're going to present any evidence, and you will rest. And I'll hear you at the side of the bench with regard to that. So now, I do want to conduct a colloquy with the defendant at this point.
Would you like them sworn, Your Honor?
Hold on a second, because I'm not sure I have my colloquy with me on the bench, despite the fact that I have quite a few binders here. I'm thinking what I need is in my office, so stay tuned. Nobody move.
Welcome to Zoom Government.
I think so.
Enter your participant ID. Please enter the meeting code. The meeting has not started.
Oh, yeah.
Please wait or try again later.
Was
Madam Clerk.
Thank you, Judge. Mr. Walsh, if you could stand and raise your right hand, please. Do you solemnly swear or affirm the testimony you shall give in the cause now in hearing should be the truth, and that you shall give all true answers to all questions as put to you by the court in the cause now in hearing? So help you God.
I do.
Thank you.
Excuse me.
You can be seated. I just didn't, was wondering, asking me if I wanted him over on the witness stand. I do not. Mr. Walsh, one important decision that all defendants in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine you. That is the right to ask you questions. If you do not testify, and you and your attorney request me to do so, during my final instructions to the jury on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify. First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own, what are we discussing,
Whether I'll testify or not in my trial.
right? Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to have?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Does any party wish me to ask any further questions before I make my findings?
No, Your Honor.
No, Your Honor.
I find that the defendant, Brian Walsh, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial, and that he's done so with the knowledge of its consequences. I accept his decision. We can bring the jury in.
Hear ye, hear ye, hear ye. All persons having anything to do with the Honorable Diane Fernandez, Justice of the Norfolk Superior Court, for your attention, you may be heard. Go to the Commonwealth of Massachusetts in this honorable court. Please be seated. Please turn off your cell phones.
Morning, jurors. Morning. Jurors, we'll start today with the 4 questions. Jurors, were you able to comply with my order that you not speak to anyone about this case?
Yes.
Yes. Were you able to comply with my order that you not do any research about the case?
Yes.
Were you able to comply with my order that you not go on any social media or access any news media? Yes. And do you still all have open minds? Yes. With those 4 questions all answered in the affirmative, we're ready to begin today's work. Does the defense wish to call any witnesses in this case? Defense rests?
Defense rests.
All right. I'll see counsel at the side of the bench. As different chapters. So jurors, I think I've referred to the trial as, I sort of see it as different chapters of the book. And another chapter of the book has just closed. And that is that all the evidence in the case has now been presented to you. I remind you at this time, jurors, and I reminded you of this at the close of yesterday, the defense has no burden in this case and has no burden to produce any evidence at all. And that's because, as you probably are all very well aware at this point, the burden lies on the Commonwealth to prove its case beyond a reasonable doubt, and it never shifts from the Commonwealth. All right? So what happens next? What happens next is the next chapter we're going to go to as we move towards your deliberations is that really 2 things that happens interspersed. I'll explain. 2 things that need left to be done is I need to give you my jury charge, my legal instructions to you. Then you need to hear the closing arguments of counsel, right? So the way that happens is I will give you, when we next reconvene, which is going to be tomorrow morning, and I'll tell you why in a minute. I will give you instructions on the law that's specific to the charge that's primed here, the charge that the crime that is charged here, murder. Then the lawyers will do their closing arguments. And then I come back and give you additional instructions. I call them more generalized instructions. So those 2 parts of the trial happen interspersed. A little instruction, argument, more instruction. That's going to happen tomorrow morning. And I try to be as transparent as I can in my cases. The reason for that is I don't just pull these instructions out of the ether, as you might imagine. There are instructions and guide instructions. And there, I get the input from the lawyers of what they're seeing. And that hasn't happened yet because we've moved at a pretty efficient pace. So I need to do that work with the lawyers today, and I will. And that's what we'll be doing today. What you'll be doing today is getting some rest and some sleep so you can be all rested for tomorrow morning. And I remind you, jurors, I'm going to send you off for the day. I remind you what I just checked in with you. I'm counting on you to be obedient to those rules right to the end, right? Jurors, don't speak to anyone about this case. Don't do any research about this case. Stay off of any social media, news media, and continue to have open minds as we finish these last chapters of this trial. Have a great day.
All rise to the court, please. Jurors, close your notebooks and follow me.
Couple of housekeeping things. Yesterday at the side of the bench, we had a discussion about, during Mr. Mutlu's testimony, in which I asked that a certain document be marked as, I think it was M or N for identification. Madam Clerk, which was it?
N, I believe, with the hammer?
No,
Oh, the other one was N, Your Honor.
N for identification. Has that been done? This is a question to the defense. On cross,
Page 53 of that
I
transcript.
want that
Your
whole
Honor.
document to be marked for identification. Has that been done?
Okay, I'll get that to the court this morning.
And just so the record is clear, as I understand it, that is a multi-page document of which Mr. Mutlu was asked to review a single page of, but it comprises a record of his police interview. Is that correct?
That's correct, Your Honor.
Are the parties ready to do the charge conference, recognizing that I haven't given you a draft yet because of the way things played out? I did stay last night and draft the jury instructions with the benefit of two things so far that I considered, or at least three things. One was what I had marked for identification the other day, which is the first 2 pages of the model homicide instructions. I'd asked each of the parties to mark up, so to speak, those 2 pages of the SJC's model instructions. And so you did at my request, and I had the benefit of that information. I also received yesterday, Madam Clerk, if you could get me while I'm talking, the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I had that. I considered that as I was drafting the draft instructions yesterday, and I'll talk to you about that. What I didn't do, and I sort of made a mental, because I ran out of steam, frankly, yesterday. I know that very early in the case, before the case started, that the Commonwealth had filed pleadings with regard to jury instructions, and I made a mental note to go back to those this morning, but I didn't, frankly, have a chance to do that. Since the day is unfolding a little differently than I expected at the end of yesterday. So I tell that to you so that you know that if there's something that you wrote in there that's still relevant now, it might still be, that I don't have that fresh in my mind anyway. All right?
Yes, Your Honor.
So, said more bluntly, if there's something in that I don't go over now that you want to persist with, just.
Your Honor, there is actually, with respect to the consciousness of guilt instruction potentially, I don't know if it would make sense to take a brief break so that I could collect my notes on that topic.
All right. I will take a brief break before we, and what I'm going to intend is this. The draft instructions as I have them right now includes what I tried to do is, when I was scratching my head, saying to myself, why do they want this instruction in? I put it in anyway, and then I put it in italics so that should be your clue that I'm questioning either why this is in here. For instance, that the killing must be a human being that the defense has asked for. Question mark, why are they asking for that? So the italics either means you asked for it, I'm questioning why you want it, be prepared to answer that question. Or in the instance of the instruction, I have instructions drafted right now for, and this is in part 2 of the instructions, impeachment by prior conviction impeachment by prior inconsistent statement, and impeachment by prior bad act. And in particular, in the prior bad act, I took a swing at attempting to fairly describe the evidence that's been presented to the jury with regard to the defendant's bad acts. I tried to do it neutrally, but there may be other words that you like better. So those are in italics, even though the whole instruction isn't in italics. Who's closing for the defense?
I am.
And who's closing for the Commonwealth? The address of the refuse center, 300 Forest Street, Peabody.
Yes, Your Honor.
The defense now seeking the instruction with regard to the defendant's right not to testify.
Yes, Your Honor.
I'll add it. Commonwealth seeking a mode of instruction.
Yes, Your Honor.
Again, look for the highlighted language in the consciousness of guilt instruction and see if there's some other language you would prefer that adequately captures trial evidence. All right, let me propose this. I'm going to make those edits and additions based on the information that you just provided. And then I'm going to have Madam Clerk shoot you a copy of the draft instructions. And I know you probably want to be spending your afternoons working on the closing arguments. So I think it would be reasonable, given what I think is relative to other cases, the instructions are pretty straightforward. By that, I mean, there also was a lot of agreement with regard to your submissions. And so it's part of the second half of the instructions that the special instructions. I will go back and look at what the Commonwealth submitted early on in the case. Should I presume that everything you wrote then you're still pursuing today? 88 Cusick.
Yes, Your Honor. The Commonwealth was seeking a direct and circumstantial evidence instruction, a consciousness of guilt from the MCLE instructions, and an expert witness instruction.
All of those instructions are presently in the charge, in the draft charge. So thank you, because that prevents me from trying to find out where it is.
Yes, Your Honor. It's under general instructions at the back of the pleading, the preliminary request for jury instructions, and we just provided the name of the instruction from MCLE.
All right. I don't know if I probably grabbed it. I'm not a huge consumer of the MCLE instructions. I usually use other sources, but you can see what I came up with, and you can tell me whether you disagree with it. But we talked about the consciousness of guilt instruction, and it does not, I've never given, as far as I recall, a version that put my thumb on the weight of the evidence. So it presently either says you've heard evidence suggesting, what page is it on? Hold on, it's on page 27. Yeah, it's some evidence suggesting. I've never, I don't think to my knowledge or recollection, I've never used anything that was stronger than that. Yes, counsel.
I just wanted to say, I hope you haven't spent any time on this. The object of the killing must be a human being. You mentioned that this morning,
It was just not crossed out of your version, I don't believe.
and it should have been.
It's not an issue.
I know. I said
So,
it should have been.
so just take it, can I take it out?
Yes.
Thank you. I didn't spend any time on that. There are other things I spent, like about 5 issues that were of interest to me, but I learned quite a bit researching those, so didn't have a chance to look at those issues recently, and it's always good to remind yourself of them. I'll take that object of the killing out. All right, so let me get these to you, and I'm going to suggest, what's it, 9:30? Does 11 o'clock sound reasonable?
Yes, Your Honor.
Gives you an hour and a half to stew on. I'm going to get them to you in about 10 minutes. I don't have much to change here from what I drafted. 10:30?
Yes.
Sounds good.
10:30 it is. If you need 11, you let me know, but we'll say presumptively 10:30.
Your Honor, could the Commonwealth also request the cases the court referenced about the extent the Commonwealth
I'll
can
get you
mention
those.
opening?
I will get you those. There are parameters. I looked at it about 2 or 3 days ago, maybe over the weekend, something like that. Again, something I hadn't looked at in a while, and it's always good to look at the law. But I'll get it to you.
Thank you, Your Honor.
All rise.
Identify yourselves. Counsel is present in court. Counsel starting with the Commonwealth. Kindly identify yourselves for the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning.
Good morning, Your Honor. Ann Yass for the Commonwealth.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walsh.
Morning, Your Honor. Larry Chip.
Morning. We need the defendant.
Thank you, gentlemen.
Your Honor, for the record, the defendant's present in the courtroom.
Thank you, Madam Clerk. All right, at this day, the defense raised with me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
You do not? All right. Does that moot every issue? Does that moot every issue that I researched last night?
I apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is to defense intend to call any other witnesses.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day. Let me just put in the record, so the record is complete. The Commonwealth previously, and I ruled on this at the side of the bench previously, the Commonwealth previously asked this court to exclude the defendant's plea of guilty. And I guess the only way that would come in at this point is if he were testifying. But I just want to put in, to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously, I want to put in the reason why I excluded that testimony now. The Commonwealth did file a motion in limine to exclude evidence that the defendant pled guilty to misleading the police into Anna Walsh's disappearance and improper disposal of her body. After consideration, I allowed and still am allowing the Commonwealth's motion for 2 reasons. First, the defendant has failed to show how such evidence is relevant to the remaining charge of murder. And I specifically acknowledge that I read this morning the defense's motion to admit the evidence of his guilty plea, which has been docketed as 216. That was filed on December 11th, 2025, this morning, I believe. I have read it, but it doesn't do anything more than to set forth the elements of the crimes of murder. Based on defense counsel's opening statement, it appeared that the defendant was going to testify in this trial. And at that time, he could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the 2 charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge. As explained by the SJC in Commonwealth versus A Juvenile, 396 Mass 108, 112, it's well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this. Continuing with this case, the role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez, 70 Mass Appellate Court, 699-701, 2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding in A Juvenile applies with equal force. If the defense was permitted to tell the jury that he pled guilty to the 2 lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge. Indeed, the defendant has not offered any other rationale for the entrance of such evidence. And as was stated in Commonwealth versus Ferreira, 373 Mass 116, 124, 1977 case, the jury's function is not to weigh possible verdicts with an eye towards dispensing mercy in certain cases or imposing heavier penalties in others. Rather, the jury's function is solely one of fact-finding with respect to the legal standards regarding innocence or guilt. Accordingly, the defendant is not permitted and has not been permitted to put evidence before the jury of his prior guilty pleas in this matter. And Madam Clerk alerted me to also file this morning 321, pause, the Commonwealth supplemental motion in limine to exclude evidence of the November 2025 guilty plea, which I will concede I did not read because I just got it when I stepped on the bench, but I'm not sure it makes a difference in light
I
of
think
my
it's
ruling.
moot at this time, Your Honor. Thank you.
All right, is 216 something you filed earlier? Why does it have this number?
No, that's my error, Judge. That's my error. I corrected it on the original. It should be 318. It's my poor vision.
Okay, so just so the record's clear, when I said a moment ago, I did review what the defendant filed this morning. It's just not 216, it's 318. All right, on the docket. All right, I see that I have two other pleadings up here, which I will address in brief. One of them I was going to address anyway. It's in substance, maybe not exactly as it's presented. Those are items number 319 and 320. Let me talk about 319. I haven't read it either. It's a motion to prevent the Commonwealth from basically, I believe an attorney Tipton, you can, or Porges, you can illuminate me greater, but you don't want them saying he promised you something in the opening statement that he didn't deliver.
That's right, and after consulting with the Commonwealth this morning, they have no intention, they've told us they have no intention of doing that.
So I have already pulled out some case law on this and where the boundaries are, and I was going to give it to you in the charge conference anyway to make sure that you were aware where the boundaries are. The SJC has spoken on this issue of what's permissible and what isn't. The Commonwealth is allowed to get into it a little bit. I will alert you to those cases, and that's where I intend to draw the line as to what's permissible. I probably have them on my bench right now, but I couldn't tell you where they are. But when we get to the charge conference, I'll give those to you so you both have the benefit of my research on that issue. The other motion, 320, is I expect the defense will renew after I bring in the jury, ask you if you're going to present any evidence, and you will rest. And I'll hear you at the side of the bench with regard to that. So now, I do want to conduct the colloquy with the defendant at this point.
Would you like them sworn, Your Honor?
Hold on a second, because I'm not sure I have my colloquy with me on the bench, despite the fact that I have quite a few binders here. I think the one I need is in my office, so stay tuned. Nobody move.
Welcome to Zoom Government.
You see the clerk for a second.
Madam Clerk.
Thank you, Judge. Mr. Walsh, if you could stand and raise your right hand, please. Do you solemnly swear or affirm the testimony you shall give in the cause now in hearing shall be the truth, and that you shall give all true answers to all questions as put to you by the court in the cause now in hearing, so help you God?
I do.
Thank you.
Excuse me.
You can be seated. I just didn't, was wondering if you were asking me if I wanted him over on the witness stand. I do not. Decision that all defendants in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine you. That is the right to ask you questions. If you do not testify, and you and your attorney request me to do so, during my final instructions to the jury in the law on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify. First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own words, what are we discussing?
Whether I'll testify or not in my trial.
Right? Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to testify on your own behalf?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Does any party wish me to ask any further questions before I make my findings?
No, Your Honor.
No, Your Honor.
I find that the defendant, Brian Walshe, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial, and that he's done so with the knowledge of its consequences. I accept his decision. We can bring the jury in.
Diane Fernandez, Justice of the Norfolk Superior Court, for your attention, you may be heard. Once you have a call from Massachusetts in this honorable court, please be seated. Please turn off your cell phones.
Morning, jurors. Morning. Jurors, we'll start today with the 4 questions. Jurors, were you able to comply with my order that you not speak to anyone about this case?
Yes.
Yes. Were you able to comply with my order that you not do any research about the case?
Yes.
Able to comply with my order that you not go on any social media or access any news media? Yes. And you still all have open minds? Yes. With those 4 questions all answered in the affirmative, we're ready to begin today's work. Does the defense wish to call any witnesses in this case?
We do not, Judge.
Defense rests?
Defense rests.
All right. I'll see counsel at the side of the bench. The jurors, I think I've referred to the trial as, I sort of see it as different chapters of the book. Another chapter of the book has just closed, and that is that all the evidence in the case has now been presented to you. I remind you at this time, jurors, and I reminded you of this at the close of yesterday, the defense has no burden in this case and has no burden to produce any evidence at all. And that's because, as you probably are all very well aware at this point, the burden lies on the Commonwealth to prove its case beyond a reasonable doubt, and it never shifts from the Commonwealth. All right? So what happens next? What happens next is the next chapter we're going to go to as we move towards your deliberations is that really two things that happens interspersed. I'll explain. The two things that need left to be done is I need to give you my jury charge, my legal instructions to you. And then you need to hear the closing arguments of counsel, right? So the way that happens is I will give you, when we next reconvene, which is going to be tomorrow morning, and I'll tell you why in a minute. I will give you instructions on the law that's specific to the charge that's primed here, the charge that the crime that is charged here, murder. Then the lawyers will do their closing arguments. And then I come back and give you additional instructions. I call them more generalized instructions. So those two parts of the trial happen interspersed. A little instruction, argument, more instruction. That's going to happen tomorrow morning. And I try to be as transparent as I can in my cases. The reason for that is I don't just pull these instructions out of the ether, as you might imagine. There are instructions and guide instructions. And there, I get the input from the lawyers of what they're seeing. And that hasn't happened yet because we've moved at a pretty efficient pace. So I need to do that work with the lawyers today, and I will. And that's what we'll be doing today. What you'll be doing today is getting some rest and some sleep so you can be all rested for tomorrow morning. And I remind you, jurors, I'm going to send you off for the day. I remind you what I just checked in with you. I'm counting on you to be obedient to those rules right to the end, right? Jurors, don't speak to anyone about this case. Don't do any research about this case. Stay off of any social media, news media, and continue to have open minds as we finish these last chapters of this trial. Have a great day.
All rise for the court, please. Jurors, close your notebooks and follow me.
Couple of housekeeping things. Yesterday at the side of the bench, we had a discussion about, during Mr. Mootlu's testimony, in which I asked that a certain document be marked as, I think it was M or N for identification. Madam Clerk, which was it?
N, I believe. With the hammer?
No.
Oh, the other one was N, Your Honor.
N for identification. Has that been done? This is a question to the defense. On cross.
Page 53 of that transcript.
I want that
Your
whole
Honor.
document to be marked for identification. Has that been done?
Okay, I'll get that to the court this morning.
And just so the record is clear, as I understand it, that is a multi-page document of which Mr. Mootlu was asked to review a single page of, but it comprises a record of his police interview. Is that correct?
That's correct, Your Honor.
Are the parties ready to do the charge conference, recognizing that I haven't given you a draft yet because of the way things played out? I did stay last night and draft the jury instructions with the benefit of two things so far that I'd considered, or at least three things. One was what I had marked for identification the other day, which is the first 2 pages of the model homicide instructions. I'd asked each of the parties to mark up, so to speak, those 2 pages of the SJC's model instructions. And so you did at my request, and I have had the benefit of that information. I also received yesterday, Madam Clerk, if you could get me while I'm talking, the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I had that. I considered that as I was drafting the draft instructions yesterday, and I'll talk to you about that. What I didn't do, and I sort of made a mental, because I ran out of steam, frankly, yesterday. I know that very early in the case, before the case started, that the Commonwealth had filed pleadings with regard to jury instructions, and I made a mental note to go back to those this morning, but I didn't, frankly, have a chance to do that since the day is unfolding a little differently than I expected at the end of yesterday. So I tell that to you, something that you wrote in there that's still relevant now, it might still be, that I don't have that fresh in my mind anyway. All right?
Yes, Your Honor.
So, said more bluntly, if there's something in that I don't go over now that you want to persist with, just.
Your Honor, there is actually, with respect to the consciousness of guilt instruction potentially, I don't know if it would make sense to take a brief break so that I could collect my notes on that topic.
All right. I will take a brief break before we, and what I am going to intend is this. The draft instructions as I have them right now includes what I tried to do is, when I was scratching my head, saying to myself, why do they want this instruction in? I put it in anyway, and then I put it in italics, so that should be your clue that I'm questioning either why this is in here. For instance, the object of the killing must be a human being that the defense has asked for. Question mark, why are they asking for that? So the italics either means you asked for it, I'm questioning why you want it, be prepared to answer that question. Or in the instance of the instruction I have it right now and this is in part 2 of the instructions, impeachment by prior conviction, impeachment by prior inconsistent statement, and impeachment by prior bad act. And in particular, in the prior bad act, I took a swing at attempting to fairly describe the evidence that's been presented to the jury with regard to the defendant's bad acts. I tried to do it neutrally, but there may be other words that you like better. So those are in italics, even though the whole instruction isn't in italics. Who's closing for the defense?
I am.
And who's closing for the Commonwealth? The address of the refuse center, 300 Forest Street, Peabody?
Yes, Your Honor.
The defense now seeking the instruction with regard to the defendant's right not to testify.
Yes, Your Honor.
I'll add it. Commonwealth seeking a motive instruction.
Yes, Your Honor.
Again, look for the highlighted language in the consciousness of guilt instruction and see if there's some other language you would prefer that adequately captures trial evidence. All right, let me propose this. I'm going to make those edits and additions based on the information that you just provided. And then I'm going to have Madam Clerk shoot you a copy of the draft instructions. And I know you probably want to be spending your afternoons working on the closing arguments. So I think it would be reasonable, given what I think is relative to other cases, the instructions are pretty straightforward. By that, I mean, there also was a lot of agreement with regard to your submissions as to what you wanted in these instructions. And so it's for the second half of the instructions that the special instructions. I will go back and look at what the Commonwealth submitted early on in the case. Should I presume that everything you wrote then you're still pursuing today? ADA Cusick.
Yes, Your Honor. The Commonwealth was seeking a direct and circumstantial evidence instruction, a consciousness of guilt from the MCLE instructions, and an expert witness instruction.
All of those instructions are presently in the charge, in the draft charge. So thank you, because that prevents me from trying to find out where it is.
Yes, Your Honor. It's under general instructions at the back of the pleading, the preliminary request for jury instructions, and we just provided the name of the instruction from MCLE.
All right. I don't know if I probably grabbed it. I'm not a huge consumer of the MCLE instructions. I usually use other sources, but you can see what I came up with, and you can tell me whether you disagree with it. But we talked about the consciousness of guilt instruction, and it does not, I've never given, as far as I recall, a version that put my thumb on the weight of the evidence. So it presently either says you've heard evidence suggesting, what page is it on? Hold on, it's on page 27. Yeah, it's some evidence suggesting. I've never, I don't think to my knowledge or recollection, I've never used anything that was stronger than that. Yes, counsel.
I just wanted to say, I hope you haven't spent any time on this. The object of the killing must be a human being. You mentioned that this morning,
It was just not crossed out of your version, I don't believe.
and it should have been.
It's not an issue.
I know. I said
So,
it should have been.
so just take it, can I take it out?
Yes.
Thank you. I didn't spend any time on that. There are other things I spent, like about 5 issues that were of interest to me, but I learned quite a bit researching those, so didn't have a chance to look at those issues recently, and it's always good to remind yourself of them. I'll take that object of the killing out. All right, so let me get these to you, and I'm going to suggest, what's it, 9:30? Does 11 o'clock sound reasonable?
Yes, Your Honor.
Gives you an hour and a half to stew on. I'm going to get them to you in about 10 minutes. I don't have much to change here from what I drafted. 10:30?
Yes.
Sounds good.
10:30 it is. If you need 11, you let me know, but we'll say presumptively 10:30.
Your Honor, could the Commonwealth also request the cases the court referenced about the extent the Commonwealth
I'll get you
Convention
those.
opening?
I will get you those. There are parameters. I looked at it about 2 or 3 days ago, maybe over the weekend, something like that. Again, something I hadn't looked at in a while, and it's always good to look at the law. But I'll get it to you.
Thank you, Your Honor.
All right.
All right, I brought props. Okay, you're not going to believe this for this show today. Why am I carrying McDonald's around? Something that I generally don't usually eat, even though those fries are really great. Well, Michel Bryant.
I don't know. I can't wait to find out. Mr. Brian Walsh trial today, day 8. The Commonwealth has rested. What does that mean for tomorrow? We are going to talk about it here at Justice Through TV. Welcome.
Justice, where are you? Michael and Linda are here.
Love you, Linda.
World is justice. Will we ever find justice?
The courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be and I lead the way. Hoping justice will win the day. Listener clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
Hey everyone, Michel Bryant is in the mobile studio. Hence, we have been losing him with our Starlink because we just taped a couple members episodes. So there he is. He's coming back with it. So that's why. Oh, he's right. But that's okay. I mean, look at him.
I feel like we turned upside down.
He's in the dark. He's absolutely in the dark. Hello, everybody. Share the picture. Hit that like, subscribe button. Actually, we think we possibly have a new picture that we may use later on because, as I said, we just did a couple member episodes, membership only episodes that will then air for all of you on the weekend. And let me just put this up. Let me add this to the stage. That was how we took Michael because he was frozen there for about 10 minutes in a very dapper photograph. Could have
been much worse. It could have been much worse.
And
just now, as the open was coming on, the whole computer table that I've got set up here just fell right over. Just fell right over. So
you've obviously been hanging around me today. I began with a little bit of a fire in the wires, and we have my brand new dryer.
Oh gosh!
Then my
the
dog
mobile studio was too mobile.
Grandmother died, so you've been hanging. I mean, obviously, I'm giving those vibes across. God rest her soul for Taylor's grandmother, Taylor Anthony. Grandmother. Okay, so I would just say that, things happen every day to people, and our mobile studio falling over is probably terrible for the timing, but in the scheme of things, it's okay.
Yeah,
Now,
just a slight
I actually, do you have control of Rip and Reads?
Oh my gosh, you're really asking for it, aren't you?
I really am. Do you have the control?
Whoa, hello.
Hello.
Are you a Jets fan?
The Jets do put bags over the head. Matter of fact, I do have all of it. But this was, what is this? What bag is this? Do I have over my
That
head?
looks like Mickey D's to me.
Yeah, McDonald's. I actually am going to probably have to send it to you for a cost, because it is props for the show. Although I did eat some of it, I have to confess, even though I shouldn't have.
Eating the props.
Eating the props. This was McDonald's, Mickey D's, and the reason why it was interesting, because you were talking about it yesterday. This rip and read I have on the Walshe case, because of the DNA experts were doing they get 4 people to do steps 1 and 2, or 1 and 3, and 2 and 4.
That's right.
Right. And so that's how Mickey D's work. Well, then today, when I was looking on the Mangione, which we're going to do a whole episode hopefully on when they finish this hearing on the search warrant, that apparently it came to light, if I have read what's happening in court right, and I wasn't down in the courtroom, that the reason why there may be no video of the cops finding the gun is because Mickey D's has gotten pressed yesterday in Walshe with you, and today in Luigi Mangione's trial, because when they were transferring him from car to car so he could have his McDonald's, which they bought, that seems to be a thing, right? That's when they found the gun, and the body cameras are off in the transfer from car to car. How convenient.
How convenient. It just, these things that just seem like, could that be by accident? Was there something going on there that they didn't want? Oh, wait a minute.
Time for you to mute yourself.
Guess where I am. Stand by. And there they go.
Yeah, there you go. Actually, I haven't had McDonald's in years either. I bought it today for the prop, and also because my doctor said, you're not eating enough. And I'm a little busy. I'm running from here. I'm running to trial. I'm running back here. I don't have time for food. I have time to feed Tubi. My poor husband is getting DoorDash a lot. I'm a big DoorDash. I should get a discount for DoorDash these days. But so I decided, okay, maybe I'll have a little Mickey D's. Haven't had in a while, and then I can have the bags as props. So I kind of merged the two. I had DoorDash, merging it. So
they DoorDashed your Mickey D's, got it. And for those who were not around yesterday during the Walshe trial, I likened the lab rats to, hey, is another emergency vehicle coming? Looks like engine number 4, one of my favorites. There it goes. I think there's another one coming too. This town, it's like it's up in flames at all times with the number of rescue calls on a given day. They even had to stop in court today twice. Witnesses on the stand and like, okay, hold on, let's wait. Part of the reason for that?
No, but I've got a new defense for the McAlberts why no one came out of the lawn, because there's so many sirens all the time that there was nothing to see there.
And of course, we learned in that trial that they only use these sirens for traffic avoidance. So that at 5:36 in the morning, they didn't need it because there's no traffic. So all they had on were the lights. Now we have the rescue.
So why? You were going to tell us why? So I left our audience hanging.
In the courtroom, as lovely as it may be, there is way too much heat. And so on the street side of the courtroom, I mentioned this today, because there's only about 3 or 4 of us on that side. And the main reason is because the windows are open to regulate the heat. So, it's 35 degrees out. And when a gust comes rushing through there, it just blows you right off the pews. Yeah. But that's how they control the heat. So,
well, I wish I had that when I was in Suffolk with Hernandez, because the way the court was facing, the sun just beamed in these beautiful windows and made the judge look like God up on the bench, because there was huge windows. But it was so hot every single day. You wanted to be, you felt you wanted your beach umbrella. It was just so hot.
I'm
And it was in the
guessing,
middle of the winter.
was that an old courtroom? Old courthouse?
Yeah, it's an old health courthouse.
Yeah,
Stuff,
so they've
it's
got
not as
all of
old
them
as
have,
Dedham, but
and you can hear. I think probably even on the feed, you can hear when the groaning radiators start kicking in, and it's loud. It's like clank clank, and so that's part of the charm of an older courthouse. But
you are a voice actor. What did you just do again? Could you do that again? The radiator sound.
Clank clank. And that's why all of these vehicles streaming by are even more annoying, because the window's open to help.
Isn't that interesting? That should be a Jeopardy question.
I feel like I'm in Jeopardy. So today, Commonwealth rested. We heard yesterday from Judge Frenier that
the Walshe case. We're now switched to the
yes,
Walshe
we're back
case.
to the Walshe case, which was my reference to the McDonald's from yesterday, because so many of these lab rats were like somebody running the fry station, somebody running the burger, somebody toasting buns, somebody doing condiments. Not one of them did everything, and it just seemed very odd to me. So
kind of like medical care these days. Okay, you go here to here, you go here to here. You remember when you used to have a doctor?
Yeah, exactly. Do you actually see a doctor? Do you see a physician's assistant? So that was the McDonald's reference. Today, at the end of the day, the judge said, well, we may be at the end of evidence early tomorrow, meaning today. And it was really unclear whether she meant, is the Commonwealth going to be done, or are we just, because of scheduling, going to run out of bodies? She was just letting the jury know possible we'll run out early. And we did. At 3:10, the Commonwealth rested, with the last witness being the girlfriend, the very good friend of Anna Walshe, Ms. Kirby, Alyssa Kirby. Interesting witness. Do you have any take on her?
Yes, I have an interesting witness, because she's a really good friend out in Washington of Anna Walshe, okay? Did not know about the affair, but the most interesting take I had on her, and at one point I actually texted it to you, and let me see if I could find my text to you, okay?
You're going to reveal one of you?
Yeah, I'm going to reveal. I said, if I could, that Anna told her she wanted to be with Brian, okay, which is what the boyfriend also said, and that Brian was depressed, so that it was very hard for her at this time, because Brian was under such a mental health strain. All right, and I thought, well, you just gave Brian Walshe a mental health defense. You just told that he's under such strain. He's got problems with his mental health. I mean, why put him on the stand now? Why?
And
so
now
that was my big reveal.
And we'll see as we go through jury instructions and whether that becomes an issue, because the defense arguably now has the basis for an instruction. So we'll see if that happens. This woman, she obviously was very good friends with Anna. She broke down. She cried on the stand. And had to admit, though, although, clearly she favored Anna. Clearly she was not there to help Brian, whether she liked it or not. Some of the things she said did, in fact, help Brian. But that was not her goal. You could tell she was really upset about it. If you were to actually have a conversation with her, I'm sure she believes Brian did this, and whatever she can do to help convict him, she'd be fine with that. I get that impression. I was sitting next to your new best friend up here, Barb, and soon as this was, I thought this was very interesting.
Hi, Barb.
Barb, she's in Hingham. She said she'd be watching, so there you go. And she said I was going to ask her more about it, but she took off before the end of the day. But her gut reaction as Alyssa Kirby left was and I want to write down I think I actually wrote down the note, because I'm looking at it, I think objectively, and say, okay, she's good on this front, she's bad on that front.
Right, that's what I was doing.
Everything she is saying makes sense, considering who she is and who she knew. But I think I dropped my glasses. Oh, done it.
And she was good friends. We're seeing the whole car.
The mobile studio is far too mobile today.
She was friends for only a couple months, but they developed this friendship, and you have to wonder why it was so close. Did she need somebody to talk to? Did Anna need somebody to talk to? But she was talking to her. And she also said she was very tired, and she looked very tired. Although that picture of the two of them that's shown at the end, Anna looked great. So that's okay, Michael. I can fill in what I was going to say anyhow. When you
go ahead, keep going. I'm going to find my spot here.
I don't look great in that photograph. But what I don't get, and I also texted this to you, I said, I don't get this marriage. Okay, a lot of marriages, people having affairs. Obviously, it was revealed that she wasn't having sex with her husband for the past year because he was so depressed. So she found a new boyfriend that she really had a plan, but she really wasn't planning to be with him. She wanted to.
It was an odd plan.
She wanted to be with Brian and the kids. Some animosity. She wanted to be with Brian and the kids, but Anna didn't tell her about the affair. So there had to be a reason Anna was talking to her. And maybe Anna didn't view the affair as something that she revealed because it really didn't matter to her, as it turns out.
It was like a fling. It was like a convenience. It was like physical necessity.
Right.
I do think, that 1, 3, 5, and 10-year plan, right, that the boyfriend talked about.
Yeah.
It never came to be for obvious reasons, but it may have been more his plan than her plan.
Yeah.
You know what I mean?
Yeah. No. And so, and people do things. And she also said that Anna told her that Brian, that they had an open relationship. All right. Which I thought was also interesting.
Yeah. And I don't know. We didn't hear a definition for that. I mean, I think the common definition for open would mean multiple partners.
Right.
But it also could just mean that they were open about, the relationships outside the marriage, non-sexual. I mean, just we didn't get it fleshed out. Nobody asked for a definition.
No one asked for a definition. Probably both sides were scared for a definition.
Yeah, and I would have objected to it. I would have objected, unless you're going to get some sort of expert in there to tell us what that means, because I think it can mean a lot.
But it was really, really interesting. She wanted to look forward to being together. She wanted Brian to go to jail, do his time, and admit that he did wrong. Well, he had admitted he pled guilty, do his time, that they could all be together again, hopefully this time in Washington, D.C., because I gather she loved her job, but she wanted to be with the kids. But Brian was taking care of the kids during the week. But so they had this kind of thing worked out of some sort. So it's a different marriage than we think of the guy who's going to the guy who's going to intensely murder his wife. This was like she's explaining this, and it's a whole different relationship on her end.
Yeah, there's no doubt about it. It does not sound like, oh no, I've been found out, and then he's out to get her. It just doesn't sound like that. Okay, I found my note from Barb's reference here to Ms. Kirby. I think she was a lousy witness. That's what she said.
On whose side, though? For the prosecution or for the defense?
Well, I didn't get to flesh that out. So you have to assume, since she was a Commonwealth witness, that if somebody thinks they're a lousy witness, probably for the party that's putting her forth. Yeah. But I didn't ask that, to be all full disclosure. I didn't ask that follow-up question.
I thought that she was ended up being a good witness for the defense because she gave a mental health defense for him. I mean, that's really...
And she also didn't give anybody information about the revelation to Brian Walshe about what was going on, so that he could have a reason to be mad, a motive to be... the judge even read an instruction to the jury, reminded them that any of these things you're hearing said about Anna Walshe goes to her state of mind, not for the truth of the matter, but her state of mind. And then the judge said, as it goes to motive and intent to kill. So it was a very clear instruction to this jury that this is what the Commonwealth needs to prove. And you have to look at this only for that state of mind purpose. So
I'm not sure that I really, when I started this case, I thought for sure. My view was for sure first degree murder. How you don't cut up. We've seen these cut up cases of wives, and we have the it was Michel Troconis case in Massachusetts.
The missing body cases,
with the husband there. And also you and I come in with a bent, right? Or at least I came in with a bent that, he's definitely guilty of first degree murder. I'm not so sure. I think he absolutely killed her. I'm not sure if it's second degree because maybe he learned of the affair, or she was beginning to fall out of love with him. Maybe she told him that, according to this witness. And that would lead to more manslaughter. That would mean more heat of passion. And you combine heat of passion with a mental health defense. That's not going to get you first degree murder. I don't think.
I agree 100%. And excuse me while I use this to push a button.
I thought you were about to hit me over the head with it from afar.
Let's see.
Okay.
Ooh, let's see. Okay, I'm just trying to make sure the Starling doesn't die on us. Yeah, all of these things to me reinforced, if he did what he's accused of doing, it happened suddenly, heat of passion, a revelation about the boyfriend, a revelation about the master plan that we're going to get a divorce because I can't handle this travel, and your life is up in the air still, and you can't even, we wanted it to be a year, and we can suck it up for a year. Then he gets 37 months. I'm no math major, but that's more than 3, just short of 3
years. This is an interesting comment. Okay. Pure Duckery says, I think the mother has something to do with the unalive. I texted to you also. I thought, well, I didn't actually text you. I was on with you. Okay. At some point, and I put in the chat, I said, if this were a movie script, what you find now, because apparently the mother, according to the testimony of Ms. Kirby, the mother saw a psychic who said that Anna was having an affair, took that to Brian. Brian took that to Anna. Brian told Anna that, oh, that's ridiculous. I don't believe that for a second that you're having an affair. That didn't come out of nowhere. Okay. You and I, in reality, the jury's not going to believe that came out of nowhere. Even the mother maybe the mother had more, but if this were a movie script, you'd say the mother killed Donna, right? And then Brian was covering up to save the mother.
Protect his mom. Yeah.
To protect his mom, because they have a very weird relationship too.
There was, it's, and I did, as he left the case, but as he left the courtroom today, as he clanked out, he gave a very distinct turn and nod to mom. Not a smile, just like an acknowledgement, like glad you're here, Yeah. There was one other thing about mom that came up again. We've heard 2 things now about mom's protectiveness of son, perhaps, and today we heard about the whole holding Jem's hand. Remember that when he was there in the federal court hearing, he's there and Anna's there. They're sitting together. He's holding her, and the belief was that Diana Walshe.
Jem? Okay,
Jem is the person who ultimately hired Anna Walshe, brought her into this real estate world, and they became very close as both friends and professionals working together. But Brian was also a friend of his, and so it was kind of a weird relationship, the 3 of them. But they hung out together on New Year's Eve. He was the last one to see Anna alive, other than Brian. So
Missy says we should play Jem leaving the courthouse.
That little clip. Let me finish the story first. It was so that was one moment where it looked like Diana Walshe was not happy with Anna because she was
Diana being the mom.
Brian's mom. She's not happy because he's holding hands with her in this federal hearing, right? Then we hear from Kirby that mom was not happy about, and I'm going to remember the specific reference to it because there were a couple of different ones. Mom was not happy about her relationship with, the psychic said she was having an affair, right? That's what we heard. But she also was very judgmental about Ms. Kirby talking about Anna and her with men. So mom, really, in these 2 witnesses' eyes, clearly was a little controlling with her son or protective of her son.
And is the psychic a PI, private investigator?
I don't know. I don't know.
We need a psychic to tell us, or a private investigator. Really. What are the 2?
Right. So as Jem was leaving the court, we all kind of queued up outside because he really was a very interesting witness, and he wanted more than anything to tell this jury that they had the Walshes had a troubled marriage. There were problems with the marriage. Objection, objection, objection. He was basically giving his opinion based on what Anna had told him, although he could not remember her exact words. Well, when the only thing admissible to her state of mind are the exact words, you better know the damn exact words. And he kept throwing in his own interpretation. And ultimately, on redirect, prosecution kind of gave up. Greg Conner said, if you don't remember the exact words, fine. And he said, no, I don't remember those words. So, but the jury's already heard marital problems over and over between the witness saying it and the judge telling them to ignore it. So,
and then you have the testimony from both the other day and the testimony from Kirby today that she wanted to be with him. So she loved him. She loved him. She had no intention of breaking up with Brian Walshe.
It makes no sense if you follow the prosecution's theory. And that's why, even though there was a motion for directed verdict, as of course there always is, after the close of testimony for the state, when they rest, you pop up with your motion for directed verdict. You know, they changed the name of that here. I wrote it down because it's so ridiculous. Only in Massachusetts would they make it more complex. Let me see if I can find it here. I had to write it down because I said, there's no way I'm not going to memorize this long, drawn out, ridiculous name for it. Okay, now it's called, used to be directed verdict, and that's where it is most everywhere, right?
Yeah.
Now it is a requested finding of not guilty.
A requested finding of not guilty. Well, that makes more sense. But
So out the window is directed verdict. Okay, so now as for Jem,
yeah,
Mutlu.
we call them Muddy. We call them Muddy in our thing. He's known as for Muddy's here, but his name is Mutlu.
He's a Turkish guy. Interesting name. Very successful.
Very handsome, very debonair in a Sean Connery-like way.
When he stood up, he looked very different than when you just see his head sitting there, head and shoulders, and he was not like really tall, but very thin, I thought, compared to how he looked just as a head sitting on some shoulders. So as he's about ready to get out, I and a few colleagues here go downstairs to meet him at the base of the courthouse steps, and Missy wants to show you what happened at that point.
Okay. Oh, look at those steps. Again.
Yes, we've seen him many times.
Yeah, you want to stop and just say a couple words?
What is it you wanted the court to know? Why do you think there were marital problems?
How hard was today? What are your thoughts on Brian Walshe? Do you think he killed her? Was it hard being in there with Mr. Walshe today? I'm sorry, I need to go. Thank you very much.
You better watch out. He could get arrested here for jaywalking. Do that against the light. He crosses. He had to get the hell out of there. I mean, I don't blame the guy.
I have another viewpoint. I don't know whether she released him off a subpoena. Okay. When he finished testifying, do you know that? Did she release him off a subpoena?
Well, they aren't very formal about it. You know, they basically say, you know, any further questions, and then they say you're excused. So that could be interpreted to be released from the subpoena.
But my point is, you see Massachusetts, all of you journalists who are putting microphones in people's mouth and asking for comments, and did you think he'd do it? Blah, 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 blah. In Massachusetts, you could be accused, all of you, the whole group of you who are doing the First Amendment, of witness intimidation by asking a question. It's so stupid.
Well, luckily, I don't think we hurt his feelings, so he's
Never
good.
know.
He's good.
Never know.
Yeah.
Maybe
Never know. Could we have the video, so who knows? Anyway, so that was an interesting punctuation to the day. Obviously, the Commonwealth thought Ms. Kirby was the big finish, right? And so,
and they grouped about Muddy, and
yes,
I'm calling him Muddy because that's what we've named.
And again, if you think about it in that context, it still leaves me wanting more to get to intent to commit murder.
Unless the Commonwealth are going to say it could happen at it's one of the murder, the intent to kill can happen at a last second. Okay. I intend to kill, as opposed to, I pushed her and she fell. She's not in her pajamas. So what was it? She leaving the house? I mean, remember, they didn't find her. They found her purse. Why would he throw away her purse? Well, he had to actually, if he was going to say that she left, right? If he was going to then do a story that she left, as opposed to saying that she, rolled over and died in her bed and she was in her pajamas. They didn't find her body, so we don't, So if he testifies, they get to ask where her body is, right?
Sure, of course.
And what did he say? I don't know.
I know what I blacked it up. What would you say? So I think in part because it's always dicey to put him on, but more so because the Commonwealth, I think, has major holes in the case, and that his testifying can do nothing but help them fill those holes.
For intent.
Yes.
Yeah, for intent.
So it's is he gonna win the day? Is he gonna pull a Nick Casotis, where it looked like he was gonna sit and keep it shut, and then at the last minute, his attorney Doug Weinstein learned otherwise, and he sunk his own battleship? It could happen. Ultimately, it's his decision.
I think I called Doug Weintraub today. It's like I had a glitch. My brain had a glitch. Doug Weinstein. Yeah, Doug did such a great job getting to lesser included or possible not guilty. Maybe we didn't think not guilty, but lesser included than the defendant got on the stand. And when the defendants take the stand, the case comes down to them. And I just don't think he's going to make a good witness. I mean, it's really interesting because he's got such a strange affect in court. He's kind of smiling, right? When he's in those videos. I don't know if it was your favorite store. Was it Home Depot or Lowe's?
Might have been Home Goods.
Or Home Goods, where he's looks at his smiles, fixes his hair, but he's got a child with him as he's buying the supplies to cover the smell of wherever the body has been before he got rid of it. And also, what was the most important crucial evidence was found near his mom's dumpster. So that's why I say if you were writing a screenplay here, you'd be talking about mom even more. So not that she did anything, but you'd be talking about her more because it'd make it intriguing as a fictional screenplay.
And he feels some sort of protective quality so let me spread some of this around moms because I know she'll protect me and keep me out of trouble.
And well, she obviously, obviously she said it was a psychic. Was it a PI?
The psychic. Yeah, that I didn't have psychic.
You just psychic on your bingo card.
In. Yeah, I didn't have that. Wasn't thinking that was coming up, but it's a nice little wrinkle. Very interesting. She's a very interesting person. I could just tell. I could see.
But it was Kirby. It was Kirby relating double hearsay. It was Kirby relating the hearsay that Anna Walshe told her that supposedly Brian Walshe told her. Right. It was, I'm sure there were pretrial motions on that, but it was.
Oh, I'm sure.
What we call double hearsay, and
so you have to attack each level of hearsay to get it in.
Right. Yeah.
So, and again, it had nothing to do with the truth of the matter. Do we care if she went to a psychic? No. That would be the truth of the matter. You're not using it for that.
I have a lot of friends who go to psychics. They have Hollywood. When I read articles about Hollywood, they all have psychics.
Yeah, I don't mean I'm putting it down like, we don't care. No, I mean, it's not for the matter asserted. I went to a psychic. I don't care if you went or not. That's not what we're using that statement for. So it can come in. It's a non-hearsay purpose. So the psychic tells Brian Walsh's mom that Anna's having an affair. Brian Walsh's mom tells Brian, and there's your chain.
Well, I wouldn't call him, given all what happened today. I mean, we're still nitty whether they were going to call him. Given what happened today, I'd rest my case. If I'm you already have that people can die in their sleep unexpectedly. Kirby gave you how tired she was, right? How although she didn't look tired in the picture.
Yeah. You're right. Yeah. And there was another reference. This came up on Cross. Remember, we heard early on the 27th, and I can't remember the witness who gave this testimony. On the 27th of December, she was not feeling well, whatever that means.
Right. Kirby said that she was not feeling well.
Kirby gave us another date for that.
Oh, wow.
Yeah, on the 20th, they were going to go out. Remember, they finally arranged to go out on the 29th, and they were out karaoke, blah, blah, blah. Right. Originally, they were going on the 20th, but they had to cancel. Why? Because Anna felt sick.
So, and that goes back to the opening statements about that there was COVID hanging around, that she had been sick, blah, blah, blah. So I guess if you want to call a forensic pathologist and you want to call Dr. Banerjee, who's been on our show, you could say we should go into more of the reasons of somebody could look like that. But then the prosecution gets to do, but you didn't know that did you know that the hacksaw that he used with his DNA and her did the family? Did you know you get to go through all those facts. So I think that's a good thing.
They do get to reinforce a lot of the bad.
Right.
So, up until today, I would have said more likely than not he'll take the stand, and now I say more likely than not he will not. Still could happen, but today, again, you're in a tough spot as the defendant here because it's such a horrific act that you have admitted to.
Right.
And the jury is just hoping to link it up, and we will never know what's going on in their brain pans when they come to that conclusion.
Right.
But I do think at least it opens up the possibility of a hung jury, because if there's a person that says, I don't see it. And if
he takes a stand, it as far as I'm concerned, I mean, just him trying to explain away how he did it, where the body is with the kids, How'd you bring the kids? I mean, now, the defense attorney can argue, well, he always had the kids. He brought them everywhere. It'd be strange what do you do? Leave them at home?
Yeah, when he goes shopping.
And he wasn't buying things that were specific, that the kids could understand were specific. They will know when they grow up later on. But you never know. By the way, who has the children now? It's one question.
Well, they're in foster care, from what we understand. The real question is, whether they're split up, which is certainly more likely than not. I mean, foster family taking 3 kids 2 years each apart. I think they're now 4, 6, and 8.
Oh my gosh, breaks my heart.
Yeah, it's there's nothing good about that whole situation.
Kids are always the victims, aren't they? In every case we look at, the children are always the victims, no matter what.
Yeah.
Oh my gosh, some lawyers on the show will be asked. He knows where the body is. Yeah, of course, everything is open. Once he takes a stand, it's all open. I mean, he's waived his Fifth Amendment privilege. It is open. I just don't. I think after today, you've got look. If you were Larry Tipton, who's an excellent defense attorney, right? If you were Larry Tipton, you couldn't believe that his mental health and the talking about how bad his mental health was and how depressed he was and how it's been terrible for his mental health for a year. You couldn't believe that was coming in. You really couldn't. Okay, the way it came in, it just couldn't. The one thing to the end that he did allow them with him, she was falling out of love with him. I thought that was the one statement that hurt him from Kirby, because that gave motive for him killing her, as opposed to, I still was going to stay with him. I'm still was going to stay with him, and then I'm falling out of love with him. But then, how close was Kirby when she didn't even know? When Anna didn't even share with her that she was having.
Yeah, that was the one statement I thought kind of slipped in, during a kind of a long rambling answer that might have been better. Corralled to either make a bigger impression or to diffuse it if you're on the defense. But yeah, that just kind of like slipped in there, because everything else you hear, to me, what was causing her the biggest problem was being apart from the kids and having to travel back and forth. Obviously, making that worse is because Brian's issues with the federal charges meant he couldn't move.
Right.
So it sounded like it was all a culmination of that frustration rather than we're having a fight here. And
because his mental health was bad, they couldn't have sexual relations, and so she sought comfort outside the marriage. Not unusual. I mean, we don't judge people. It's not unusual. Apparently, they had an open marriage. Who knows what happened in the marriage previously with him and her? Who knows? And who cares? Quite frankly, it only is relevant as it goes to motive. And if it's a relationship that she didn't think very much of, I mean, then maybe he didn't think very much of it as he found out.
Exactly. And maybe, we don't know this, maybe there's some history in which that's happened before.
We have no idea.
We have no idea. He was not a jealous guy, according to the witness testimony. He wasn't. Anna wishes he was more jealous. So
yeah.
So who else might you put on tomorrow if you don't put on the defendant and you're hesitant to put on medical examiner because of the way it opens up a lot of things? You would just do nothing. You would just rest.
I'd rest. I'd rest at this point.
Well, we're going to find out pretty early in the morning. That makes it very interesting. My timing is either very good or very bad. It was good to be here when the Commonwealth closed, and I think the witnesses today were very important. But if there's resting tomorrow by the defense, then they immediately move into instruction conference.
Right.
And they haven't really had any downtime to do a chunk of tomorrow. They could have closings on Friday.
They could have closed, right, and it would be too bad if you're not there for.
Well, I'm somewhat adjustable. I'm flexible a little bit, so we'll see how it goes.
Yeah, and so I don't know. So, but even if they do have one witness tomorrow, they still may have the charge conference and closings on Friday.
Mm-hmm.
Although this judge seems like she likes to give the attorneys time to get everything ready. Okay, it may be closings be Monday, but then you're getting closer and closer to Christmas. Now, let me tell you, Hanukkah is what? Next
Hanukkah's
Tuesday,
coming up, right? Yeah.
Tuesday, and by the end of the week, all the courts are closed. She also may want to move it to get closer to Christmas. But if you are a defense attorney, you want that jury deliberating as close to the holiday
you want to get the hell out.
Right.
Yeah, it's a Friday verdict on steroids.
Right.
And so remember, we disagreed with the judge last week, and we know nothing about the estimate of time. But last Friday, she said 2 more weeks. And here we are 3 days into the first of those 2 weeks, and the Commonwealth's done. There's not a chance in hell it's going another 7 court days. No way.
No, except that I think maybe she was telling him that's going to be the outside limits, right?
Well, I know, as we said, you'd much rather give them a longer period of time and then reward them with a shorter period of time than the opposite.
Yeah.
So especially as you get near the holidays, people just, this is not where they want to be.
Okay. So what was the most important moment to you, Michael Bryant, in the courtroom for the prosecution? Then I'm going to flip the question to you. What was the most important moment in the courtroom to you for the defense today? And then let's take it for the whole trial.
Okay. For the prosecution, and it may boil down to the same answer in terms of for the whole trial, but for the prosecution, I think that Jem Muddy
as we're calling him.
Muddy. He, I think, almost as much because of what he wasn't able to say as to what he was able to say, because getting into his impressions that there was discord is critical. If you're going to buy the motive at all that Brian Walshe wanted her gone because of whatever marital problems there were, only Jem hung that out there for the jury, even though told not to get into it, even though it was stricken. The jury heard about it. They may be dying to know exactly what the basis for it's his opinion. His interpretation might be. They'll never find out, but it's a pretty big matzo ball hanging in there over the jury when they start to think about why would Brian Walshe kill Anna? Well, Jem said there were some marital problems. So I think that was key for the prosecution.
And for the defense, the most important moment.
Then I think we got to look at Kirby because she diffused, if she's such a good friend, as it seems she was, it was diffused that even she knew there was an affair. And if she didn't know, what's the likelihood, I'm going to sound sexist here and I can't reach my Fonnie Willis button, but girls talk, girlfriends talk. And if she didn't know, what are the odds that the husband knew? I just think that that's less likely if the girlfriend doesn't know and if the girlfriend's not a conduit. So I think it's helpful that it wasn't widely known in the tight circle that we've heard from, Jem and now Kirby, wasn't widely known there was an affair. And if that's true, less likely he knew. And if that's true, where's the motive to find intent? And I know we don't need motive. People start going, you don't need motive. No, you don't. But it's one way to get to intent. And in the absence of many other factors, you got to go with what you got. And I don't see motive.
Yeah. And I see the other thing, the problem prosecution has is he didn't start buying all these cleaning fluids and doing these searches, which are really like, a stupid criminal, right? Until after she would have been dead, according to the timeline of the prosecution. Now, if you had planned to kill somebody, you'd have all that lined up. You wouldn't wait, until, he was searching literally, how to make a body, not smell, but she was dead by then.
all of that fits the defense admission. All of that, maybe you disagree, can't understand how somebody in that scenario could freak out to the point they think the best thing to do rather than to call 911 is to figure out how to get rid of the body. I get it.
That goes to intent. That goes to the intent to cover up and the intent to
it's a consciousness of guilt. Sure.
Consciousness of guilt. Right.
And the jury's allowed to make that inference. They can. And if they do, can do about it. That's their brain pan working and we don't get to know how they got there. That would be, of course, the basis for the appeal, but that's the same reason they did the motion to dismiss. It's all going to be for the basis of an appeal. So,
anyhow, but she has a great defense team. I think Larry Tipton was terrific for him.
I think that Ms. Porges was good today too.
Yeah, and and the jury has to like them. See, what people don't understand is having a likable lawyer for the defense is very important because the jury may say, said one of my friends who was a former prosecutor said he had a client who was convicted, but when he went out, the jury told him, it was hard to really convict him. He liked you so much, so much, and it's true. If there's that hedge point, they may say, well, you know what? The lawyer didn't, he was pretty good. He treated people with respect. He gave us a lot of a lot of information, and now it's for us to decide, what, and we don't know what the charges are going to be at. We don't know if the judge is gonna
that's
give
another
a
issue.
second degree and a manslaughter.
I just keep going toward a heat of passion event that took place after all was revealed. It was a new year. Let's start with a clean slate, honey. Here's what's happening. And then things spiraled out of control.
Right. And things got people, and we've seen that. Look, we watch TV shows where somebody pushes somebody in a fight, and then all of a sudden they're dead and they don't know what to do. Right?
Yeah.
And then you've got the kids who are sleeping in the house over here. I'm like, God, what do I do? And so I have gone from the plan to kill her to some type of heat of passion homicide. I just don't know what. So, so let's have a poll though. What's your favorite store that's mentioned in here? We have TJ Maxx, we have Home Goods, we have Lowe's, and we have Home Depot.
And we have Marshalls too, I think. We
have Marshalls too. Yeah. So, but we could put that all up. What is your favorite store? I don't know if we can do that in a poll and see if it comes out, and as to what my favorite store would be. It'd be real tough because the Home Goods, the parent company owns Home Goods, owns TJ Maxx. Right. I love Home Goods. The one in Seekonk is the master, is the store, where everything is. TJ Maxx to me depends on what store it's at. Like the one in New York City to me is not that great. The one down at the Jersey, the one up in Massachusetts where I had a house was fabulous. Again, maybe because they're based in Seekonk and the master store is based in Seekonk. So you're a man.
I love those stores. Oh, I love them, and I've described them.
What's your favorite? What's your favorite? Added Lowe's and Home Depot.
And I talked about this today. I would go to Lowe's instead of Home Depot if it were more convenient because I think they're always cleaner. The arrangement of the goods is more logical and spacious. Sometimes Home Depots get they feel like they're putting too much in there. But Home Depot's closest to my house. And as I've said, if I don't go there every couple of days, they call my house looking for me.
See if you're okay.
Everything all right?
I love the Home Goods in Seekonk. I don't know if I told you the story at that point.
I like the Home Goods.
I owned a Porsche convertible, a 4-seater, and I went down there to look for Halloween goods, and I found a plastic, the skeleton, the styrofoam, and how do I get it home? I'm carrying it to the car. I've got a convertible. I can open the top. Well, it bent at the middle, so I bent it and I put it in the front seat, and I strapped him into the seatbelt, and that's how I got. So I'm driving down. Nice. I'm driving down I-95 to get to to where I was, and like people are beeping at me, waving. I'm driving with a skeleton in my seat.
You could have gotten in the carpool lane, perhaps, with that.
I think everyone was driving away from me. They weren't sure it was. They knew it was fake, but it was really funny at the time that it happened because I didn't think it would cause such a hubbub. It's
so funny. I'm sure somebody was recording that on their phone.
Probably.
I like, we talk about the other stores, Home Goods, TJ Maxx, Marshalls. I like Home Goods hands down. First of all, it's not clothing for the most part, so I'm not. But the TJ Maxx, it seems to me, and Marshalls, they're just messy all the time. It looks like somebody's been through there just rifling through clothes, And if you really want to find something,
rifling through clothes.
I know, but like it's a yard sale. And so if you're looking for a particular size, do not worry about what size is on the rack because that stuff's been moved around. Oh, here's a medium in the XX. So it's an adventure, but I just don't like the sloppiness of it. I do like that corner. Usually when you go in, it's the hard right. So it's even with the register area, but it's the hard right corner, and it's like a hodgepodge of stuff. There'll be like some sort of bar decoration, a decanter, some belts. I mean, it's just a weird mix. Sometimes you find some little treasures there.
Well, of course, you can't get out of TJ Maxx without talking about the aisle where you check out, where you go in for one thing. And I found my $9.99 great T-shirt that I wanted. It's a Cheerios on it, which somebody stole, by the way, nice. Afterwards. But you go down the aisle, and all of a sudden you come out and you're $169 because you picked up all that crap going out.
Oh, they're not stupid.
Good. This looks great. Oh, maybe this.
Yep. So. That's as we used to call that. That's a POP material, POP material, point of purchase, and that's the idea by putting all that stuff right in front of your face. And in most cases, I think they control the flow of the line because they've got the numbers up there. Register 8.
Right.
register 8. And then you go, I think they limit how many there are to give you a few more people stacked up in line. So you'll spend more time in line buying those things you don't need. They're smart.
That's what happens. You buy all these things you don't need, then you get home like, I can't go
Why
driving
did I
back
get
40
this?
minutes.
I
have
got this
40 minutes to
weird
the store,
popcorn
you know?
flavored something. Yeah, no, I've been a victim. I've been sucked in.
We all have, and we all still love it.
Everybody
I mean,
has,
yeah,
yeah.
you ask everybody what's their favorite store, right? You know, and then TJ Maxx is right up there because Home Goods is not
Yep.
as accessible. There's not that many of them around, but TJ Maxx and Marshalls are right up there. Oh my gosh, somebody rides at the Pelican of a passenger seat. Don't be man, I love that. You know, so it's Massachusetts, by the way. The closings will only be an hour when they do close. They'll be limited to that. No
And I
matter
think
how
that's
long
fine.
the trial is, as we know.
The openings were 20 to 25 minutes each. So, you know, it's no Joe Tacopina here. This is not going to be Joe Tacopina, ASAP Rocky.
We're waiting. Let's take another picture, Missy. Okay, we have to grab that picture because there he is again, looking very debonair, right? I think we should take a second one because this is what happens, and maybe we should send it to Elon Musk about Starlink, you know, breaking up with us. But so he's about to say Joe Tacopina 5.5 hours. I'm surprised he didn't say Linda Kenny Baden's 6-hour closing, but there we go. So I won't give him the opportunity. Instead, I will say, we want to thank you for joining us. We want you to hit that subscribe button. Hit that subscribe button, please. We've been stopped on subscribing. You know, it's just a little bit slow. I think it's everybody, but it's also, we think that, you know, sometimes YouTube does that. The like, the share, the notify, and if you can become a member, please do. As we did members only tapings of shows earlier today. We're going to try that out, see how that works, see how you like it, and we'll go from there. But in lieu of Michael Bryant saying it, I'm going to say, I'm Linda Kenny Baden. That was Michael Bryant. This is Justice Served TV. Try to do the right thing, and we will see you tomorrow morning. At least Michael Bryant's going to be streaming from the courthouse at 9. He'll see you for the lunch hour questions, and then we'll see you for the main show at 6 o'clock. Have a great Wednesday evening.
Baden flames, they charge with mine.
Your Honor, we're back on the record in the matter of the Commonwealth versus Brian Walshe, indictment 2023-0091.
All right. Let me make some space over here. So I know you haven't had a long time to look at them, but stab it, seeing how far we can get today, and then we'll reassess whether we need to charge conference a little bit more tomorrow. All right. So my approach to charge conferences is pretty informal. And so what I'll ask for each of you to each side is, based on your initial review of the draft, where's the first page that you wish to either bring something to my attention because you either don't want it in there or you want it in a different way? So an edit or an extraction or an addition. What's the first page for the Commonwealth?
Your Honor, I'd say page 15 going into 16, the impeachment by prior conviction.
All right, stop right there. And does the defense have anything before page 15?
Number 1.
Page 1?
She just took it.
Are you joking?
No, it's, I'm sorry. Premeditation, I'm sorry, I have it 1 here, but I meant what my notes are saying, it's paragraph 1.
I said page 1 is the index. Actually, it's not really page 1.
We'd be here forever if we were starting with page.
All right, so what page?
Page 6, and I'm just lodging my objection, Judge, to, otherwise the instruction complies, in my opinion, with the model jury. I'm renewing my request for my modification that I filed on behalf of defendant's request for jury instructions concerning consciousness of guilt. The motion, paragraph 1, I am asking that the section be regarding the timing of premeditation be removed for the reasons I stated in the motion.
All right, I read your motion. Denying your request to make the change. As you know, if I agreed with you, I guess the underlying premise that I thought there was something wrong with that instruction, I agree with you. These are just model instructions. Now, they're model instructions that people have spent, I don't know, countless hours assessing the propriety of, but I don't think that that instruction is improper in any way. I think it's a proper instruction, and it's one that ought to be given in this case. So I won't modify the model SJC instruction with regard to the request, but it's been fully preserved for the appeals court if they decide to change the instruction.
Thank you, Judge.
Mm-hmm. So 15 on to 16. Anything from the defense before page 15, other than what you just mentioned?
Page 9.
Yes, counsel.
The instruction, parentheses B,
Yes.
use of a dangerous weapon.
Okay.
I think that's in the context and circumstances of this case, that instruction is very prejudicial and misleading. There is no evidence of, no direct evidence or circumstantial evidence that there was a weapon used that caused the death of Anna Walshe. And so what the jury is being allowed to do.
What about the breadcrumbs that the Commonwealth put down?
What, the breadcrumbs?
Well, why don't you argue, and then I'll let them I don't want to make their argument for them. That would be, but I want to get to the right answer. So go ahead and you argue, and then they'll argue, and you'll have an opportunity to rebut.
I understand the admission of the exhibits, and I understand the admission of the hacksaw, but to suggest to the jury that they can just pick and choose whatever, quote, weapon, even if you can define it that, and just speculate as to, well, this was used, this wasn't used, that is requiring the jury to speculate that a weapon was in fact, in the first instance, that a weapon was in fact used when there's no evidence of that. And secondly, to speculate that some of the evidence that was introduced could have been a weapon that was used without any evidence that in fact it was. And given the state of this evidence, this instruction invites the jury to speculate without sufficient evidence to reach its conclusion, and I would ask that it be removed because all it does, well, I'm repeating myself. I'll leave it at that.
All right, Commonwealth.
Your Honor, it suggests from the evidence it's a reasonable inference based on the safari history and the searches regarding getting DNA off of a knife, using a dishwasher to remove DNA. One can infer that an object was used, a dangerous weapon was used to murder Anna Walshe. There's also the evidence of the defendant's trip to the Vin and Liquors dumpster when the liquor store was closed. I believe the manager of the liquor store identified it as the defendant throwing that bag in the dumpster. That's prior to the trip to Lowe's or any of the stores where he purchased the materials. I would suggest it's a reasonable inference that a dangerous weapon was used here and would ask that the court keep that instruction in.
I might have misheard, but I thought I heard Ms. Cusick say DNA on the knife.
No, she didn't say that because there is no DNA on the knife, right?
That's correct, Your Honor.
So, but I did hear you say knife, didn't I?
Knife. I didn't hear her say knife just now.
There was a search.
There is a knife above the.
There is a knife, but there is also a search in the web history in the defendant's.
I remember that. And
regarding.
It was, the search was specific as I recall it, and remind me if my memory is wrong. Is the search with regard to the dishwasher specific to a knife?
Your Honor, may I? I believe that I can answer this question. There is a slate.com article that the defendant went to that was regarding getting, can DNA be removed from a knife?
Yes.
Then the dishwasher is
following that, right?
Follows that, and it's can the dishwasher, and I'm just trying to find the exact words.
Give me the page number on the, I think it's Exhibit 79, is that right?
It's Exhibit 79.
All right.
And then page number 4, the DNA off of a knife.
Yes.
Is page 578.
Let me get there.
Okay.
I'm there.
Okay. Then if you go to page 670.
Hold on, I just want to look at these.
Sure, I apologize.
How long does DNA last? Is it possible for DNA to take DNA, clean DNA off of a knife? And that's done on 1/1/23 at 9:34 a.m.
Yes, Your Honor.
Okay, and just putting all this evidence together, when was the Vinton's Liquor is also on the first, it's at night, because I remember it being a little dark. What time is
Yes, Your
that?
Honor, it's dark at the Vin and Liquors.
5:30, 4:30, something like
5
that?
p.m., Your Honor.
All right, okay.
And so if you were to go to page 670.
Yeah, let me get there. Yes.
And if you were to go to record 2430.
Does the dishwasher clean blood?
Yes, Your Honor.
That's at 1/1 at 1:52, also before the,
Been in liquors.
right.
And then on page 671, there is record 2433. Is it possible that a knife that
Which had blood on it remains contaminated with HIV after it's been washed with hot water and dishwasher soap.
Yes, Your Honor.
Mm-hmm.
And so,
And above it, does the dishwasher clean blood?
yes, Your Honor.
Mm-hmm.
So I think earlier you referred to breadcrumbs.
That's what I said.
And so our position would be it's a reasonable inference based on the searches, the behavior of going to Vin and Liquors, and then this is all before the Lowe's trip, where the other articles are bought for the purposes of the dismemberment. And if you look into the searches on the second, it's instructions on how to dismember. So there I see the way, what ours is that those searches show the reasonable inference that a weapon was used.
All right, there are the breadcrumbs. Attorney Tipton, back to you.
Well, I'm not going to repeat what I said. I understand the breadcrumbs argument. However, I would ask then, I think I see the writing on the wall, that the instruction will remain, but I would ask then, to be fair and balanced, that a sentence be added, that you are not to speculate whether a knife was used, or words to that effect to help guide the jury to avoid speculating about any and all of the tools and weapons, so-called weapons. I just think the jury's going to think, oh, I can cherry pick whatever I want to and call it a weapon and use it to find the defendant guilty of first-degree murder. And I'm trying to make sure that the jury does not get such a broad instruction that allows them to speculate. So I'll leave it at that.
Well, I'll give some more thought about whether I add some language in there with regard to speculation. And if you wish, you can provide me with some recommended language. But as you know, the whole issue with speculation is handled quite completely in other parts of the instruction. But I'll think about it.
I will send the court, if it's okay, I'll send an email to the court today with suggested language.
All right. As of this time, the instruction is going in and subject to any additional edits. But I think there's enough there that the Commonwealth has presented, as I said, the breadcrumbs. Which, you know, this case is what it is. It's been a circumstantial case from the beginning. And so those breadcrumbs are important for the Commonwealth's case. And I think they've properly established it to a sufficient degree to get this instruction about use of a dangerous weapon. But I'm also mindful of what you say. I'll go back and look at the section about the prohibition against any speculation or guesswork and see if I feel like it accurately and completely addresses those concerns. And I'll be open to seeing whether there's something else that needs to be added to make it more easy for the jury to digest this aspect. That's all I can say right now. All right. We're still at the defense. Anything else before page 15?
No.
All right, so now we'll move to the other side. What is your, I'm moving to page 15. Did you say 15 into 16?
The impeachment by prior conviction.
Yes.
And
I guess I lifted part of this language from the defense's request.
Your Honor, this appears to have language suggesting a testifying person being impeached.
That's probably because when the defense, I lifted it from your instructions and at a time when I think that was the expectation, but let me go back. Well, that first sentence, they have heard evidence through a stipulation, right? Is it later than that I only read the first sentence so far. You've heard evidence, they have through stipulation, right?
Yes, Your Honor, that
sentence is okay.
It's on the next page only for the limited purpose, and I suggested limited purpose.
I see. So does the whole thing come out?
Your Honor, I note in Commonwealth's motion in limine number 12, paper 198, the Commonwealth laid out the purpose for which it was seeking to bring in the evidence of the federal charge. Perhaps that language from that could be substituted, as you may only consider this evidence to understand the relationship between the defendant and the victim, or something of that nature, to understand the complete circumstances of the situation in the home at the time of the events at issue here.
Well, I don't like that.
I think, Your Honor, the model instructions all do seem to include, you may only use this for the limited purpose of, and I suggest they should be given a purpose and.
Well, but it's not impeachment. I mean, I did put that in there last night based on the information I had at that time. But that prior felony conviction is no longer impeachment. So it just seems to me like it should be out.
We think it should be out.
Then maybe it should be out.
I mean, it's no longer impeaching him, and the relevance of the prior federal conviction goes to motive intent, it seems to me, right?
Your Honor, I suggest there were reasons it was introduced to understand the relationship in the home as way of a shorthand. So, but I agree, it is not impeachment evidence.
All right. My present ruling is that's whole section's coming out now. The reason the impeachment by prior inconsistent statement is now in italics is, I'm sure that happened with some witness, but I'm not 100% sure.
I don't think it did. At least.
Anybody?
I don't want to speak for you.
Your Honor, I think some witnesses may have testified a little bit differently than they had previously and were shown documents. I don't know that it rose to the level of impeachment, but there was some questioning of some witnesses about something they had said previously.
Yeah, I just don't think that we ever got to a statement. I don't remember anybody grabbing a grand jury transcript and cross-examining. The closest we got to it, I think, was Jem yesterday, Mr. Mutlu yesterday, and that wasn't with a prior statement. It was his prior statement, but he just said, I don't remember. So was that enough to warrant the instruction?
Certainly, if the defense wants it out, we agree we should take that out.
I don't need to give them more instructions that they're wondering, what the heck is she talking about? So I'm inclined to take it out.
And we have no objection.
All right, that's why it was in italics before.
Your Honor, then the impeachment by defendant's prior bad act.
Yes.
With this, I would suggest that the lying and the conveying of the body are part and parcel of the murder at this point. It's the disposal of the evidence of the crime and the lying about what he had done. I would suggest it's not a prior bad act. It's part of the evidence of the case.
It's an interesting question.
There's many interesting questions in this case, Your Honor, no doubt.
It's an interesting question whether, where are you drawing the line of a prior bad act occurring? Can you have a prior bad act that's part and parcel? Is it prior to this time? Is it prior to the crime that was charged?
It's arguably subsequent, Your Honor, but.
Right.
I mean, it's arguably.
What about the lying to his federal probation officer?
That would appear to be a bad act, arguably a subsequent bad act, but.
Yes.
I don't want to interrupt. I tried to address what I believe are prior and subsequent bad acts in our pleading at page 6. And I took it from the Massachusetts Jury Trial Bench Book, and I modified it only to accommodate what I believe is relevant and pertinent. And the gist of that model instruction is to make sure that the jury if they hear what they consider to be bad, and I frame our instruction and subsequent bad acts, that he's not charged with those, and that they have to, just like the model instruction says, if they deem those to be bad or subsequent bad acts, they can only use them for a limited purpose. And I think that this jury will probably be asking themselves, I don't know who in the world wouldn't ask themselves, that's a bad thing to do, if they believe that the body was dismembered, and if they believe that the body was disposed of in bags. Anybody's going to think that's a bad act. And they need to be instructed that they can't, he was not charged with anything, and therefore they can only use that evidence in a limited basis. And I don't much care for the specific language of motive or anything, but it is the model instruction. And I think I would try to parse.
So I'm looking now, and that really deals with the art fraud, right? Are we on the same page,
Yes,
Attorney
we are.
Tipton?
We are.
But are you suggesting, I just want to make sure I understand what the respective positions are. Are you suggesting then that you want to expand that, so you want an instruction to the jury that includes the language that I have in there, which is lying to the police and disposing of the body of Anna Walshe?
Well,
and the lying to the probate. So that's not what's in here, but are you saying do what you did, Judge, in the instruction, but add what I want in instruction 6? Is that what you're telling me?
yes.
Okay.
But
Do you want that to be included? So in the proposed instruction, and just so the record's sort of clear, I'm talking about the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I don't know what the docket number is, but I got that. It was filed yesterday, December 10th. And I'm looking in particular at your request number 4, prior and subsequent bad acts. That's what you were referring to, Attorney Shipton. Okay, and so in that, as you initially drafted it yesterday, it was about the art fraud, but you're now suggesting that that would be an appropriate instruction also for the other bad acts that I've identified in my draft on page 17 under impeachment.
yes, Your Honor, I was anticipating there to be a proposed other instruction like you had, but yes, I
Okay.
would ask then that.
So I think I understand what the ask is now.
Right.
And so now I'll go to the Commonwealth.
Your Honor, I think I understand it better as well. It also says in the instruction about the middle of it, if you credit the statement, I don't know that we're specifically talking about a statement here. And maybe that could be expanded if the court is inclined to keep that instruction in.
Well, I think the language comes in that defendant hasn't been charged with committing any other crimes other than murder. I'm just pausing there because if I move the federal art conviction in, somebody could wordsmith that and says, oh, yes, he was. He pled guilty to a federal crime. Maybe the better way to say it is the only charge you need to consider is the present charge of murder. You looking at the first sentence?
Yes.
Let me take a minute. All right, so if I say something along the lines of, the only charge the defendant is now facing is the charge of murder. You've heard mention of other acts allegedly done by the defendant, namely, and I wrote a few things in there, and it would seem to me what the defense is asking is that I add, the language that you have in your request was including acts involving a federal case concerning art fraud that he was charged with in 2018 and sentenced in 2024, comma, I'll just put them in date orders, right? Lying to the police and or disposing of the body of Anna Walshe and or lying to his federal probation officer. So all four things would go into that parenthetical.
Good.
Okay. And then, then I would pick up with what the defense has. You may not take the defendant's prior acts as substitute proof for that they committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. And then the rest of that, you see that all there. All right. What do you think about that, Kamala?
Will the court be removing the, but if you credit the statement sentence?
Yeah, no, what I would do is, I'd make the change so that the only charge the defendant is now facing is the charge of murder. You've heard mention of other acts allegedly done by the defendant, namely, and then I would go to the defense's suggestion, namely, acts involving a federal case concerning art fraud and that he was charged with in 2018 and sentenced in 2024, semicolon, lying to the police, semicolon, and or disposing of the body of Anna Walshe, semicolon, and or lying to his federal probation officer, end parentheses. Then pick up with the defense's request and follow that through the end. You may not take blah, 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 right through to it would be extremely unfair to consider this evidence for those purposes. That's where I think I'll end it.
So you're not,
Then I go back. I don't think that's appropriate to add the for one thing.
the last two sentences?
That's right.
I will just say, Judge, that those sentences are contained in the model instruction at page 343.
I'll take a look at it, but it seems to me then if I put that thing in there, then I've got to, I don't know what I do about the other things. Because you can see the issue that raises.
Your Honor, there's also the possibility that maybe this instruction should be given around the same time as the consciousness of guilt, because it almost seems I don't have them both right in front of me, but it almost seems like we might be telling the jury different things about how they can handle the evidence of lying to police and the conveying of the body of Anna Walshe.
Well, that consciousness of guilt is before here, isn't it? Maybe?
I believe it's on page 27.
Oh. Well, I had this all in this section because I thought I'll put the 3 impeachment things, but now 2 of them are gone. So it doesn't make any sense, I suppose, standing alone. Maybe we just go straight from witness credibility to experts, which makes more sense, and move this impeachment paragraph later in the instruction. What do we think about putting it either around the vicinity of the consciousness of guilt instruction?
Well, My comment would be, I'm objecting to the consciousness of guilt, so
I know you are. I know you are. It seems to make more sense in that area. So I'm going to move it probably before or after the consciousness of guilt instruction, somewhere in that vicinity. And if you have any strong preferences, you let me know when we get down to page 27. Recognizing you don't want it at all. But I'll edit the impeachment proportion of what the defense has requested and add in specifically the federal case. That's all I can tell you for now. We can to be continued on tomorrow if we need to discuss it more.
and I understand the court's not going to include the last two sentences, so I'll just lodge my objection.
Okay. So lodged. What's the next edit that the Commonwealth has?
Commonwealth has page 27.
What's the next edit the defense has?
27.
Nobody likes penny 27. What did I do on that page? Let us see. Okay. That's COG. Who wants to go first with what I got wrong?
Your Honor, I would suggest here in the italicized language,
Yes.
in the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest, and that he may have taken steps to conceal the disposal of Anna Walshe's body. I would just suggest that that should be tried to conceal the disposal of Anna Walshe's body. And in the...
Well, the fact that it was unsuccessful is something you can argue. I mean, there is some evidence that he may have taken steps, right? That's not inaccurate.
Correct, Your Honor, that's accurate.
What do you want me to add?
I was thinking you could subtract some words and perhaps make it more concise, but that is certainly
All right,
accurate.
so what do you want me to subtract?
Rather than saying taken steps to conceal the disposal of Anna Walshe's body, it's tried to conceal Anna Walshe's body. It's not so much that he was concealing the disposal of it, he was concealing the body itself.
So you want me to taken steps to conceal Anna Walshe's body after death?
Yes, Your Honor, because it's the body itself. It's not so much the concealment of the body, but it's the steps to
conceal
dispose
the body,
of it.
not
Yes.
the disposal of the body.
Yes, Your Honor.
All right, that's probably more accurate. So under the Commonwealth's request, I would delete the 3 words, the disposal of.
Will you add the word tried? I thought I heard the Commonwealth asking for tried.
Commonwealth's content with how the court articulated
Well, attempted to take steps might be consistent with the evidence, but then that puts my thumb on it a little bit because it presumes that that was evidence of her body.
All I was responding to was the Commonwealth suggested the word tried. I think that is more consistent with what the evidence shows. I'm just talking about tried, not waiving any argument to the conscience.
All right, I'm going to leave it like it is with the removal of the disposal of. I don't like the tried part.
In the next paragraph, Your Honor, in the italicized, defendant did attempt to provide false information. I believe it would be did provide false information.
And there I got the language right in the second attempt in terms of what you just pointed out in the
Yes, Your Honor.
earlier paragraph. Even a blind squirrel finds a nut every once in a while. All right, any other edits to that consciousness of guilt instruction? Recognizing the defendant doesn't want it. And that objection is noted and lodged.
Are you done?
I think she's done.
So, once again, I refer to our prior pleading. And on page 4,
Yes.
I'm asking that be included. And I modeled that trying to find the citation. I modeled that after what I believe to be the gist of a supplemental instruction 9:22, and it's the district court. And the heading for that supplemental instruction that's included refers to where evidence is where such evidence is of another crime. It goes on to say, I caution you in considering such evidence that the defendant is not on trial for, then it has a blank intended,
Right.
and that's what I do.
But now that I'm moving down the other section that we just discussed, which far more in a more detailed fashion addresses that.
You mean in the prior?
Yes, because now that's going to sit right on top of this one.
Well, but I think that the reason I'm pressing this, notwithstanding this other instruction, is because I think just the title alone draws attention to the jury, where they're hearing a different instruction entitled consciousness of guilt. And I don't know that jury will take some language from a prior instruction and import it into this one. And it's important for them, in my opinion, in our opinion, to have context for how they use so-called consciousness of guilt evidence. And the other thing is, when you talk about consciousness of guilt evidence, the case law is clear, and the instruction says they can't rely on consciousness of guilt evidence alone. And I think it then, since we don't want the instruction in the first instance, at least it gives them better context for how to apply what they may deem to be consciousness of guilt evidence, especially where you hear all of these other acts. And yes, they will get the prior bad acts if you juxtapose it before this instruction.
I actually think it's better right after it, as I'm thinking about it, because it leaves them with it puts them in that moment, and then you may not use it for this purpose. As you were arguing, I'm like, that's not going before, it should go after.
Right.
Because
But I guess I'm just pressing this supplement. It's primarily based on this Model 9.
I'll go back and look at it, and I'm going to see how it feels once I've moved things around and how it reads. All right? And of course, you know this is coming, so you will, I am sure, as you all, I know you will. You're going to take those parts of my instructions that you want to highlight to the jury and put them in part of your closing arguments. And so you'll know where it is, and you can point directly to it so that you highlight. I'm going to tell them, take all my instructions as a whole. You're going to drill them into the ones that you think best suits your client's argument, including this one. But anyway.
I may, but
or not.
Having said that, I guess I just want to ask a question.
Yes.
Does the court intend to supply written instructions?
So what I do is I don't give them a written instruction during the actual charge. And there's a very simple, I'm a very practical person. I've been sitting on the bench now since 2017. And not once, and I'm not proud of this. There are other judges that do a better job at this. There's not once, no matter how many times I read this, no matter how many times you read it, there's always a wayward S that sticks in there, charges instead of charge, or some other less than perfect product as I read it. And I edit those on the fly, and I tell them, typically, it's my oral instructions, not what you put in the writing. I've never had something that's been a huge guffaw, but it could happen. I don't think it's going to happen in this case, but I don't finalize those to them, made those edits. I sort of a running game I have with myself. When are you going to get it right? Exactly right. Hasn't happened yet. I don't know that it's going to happen on this case. There's always some little niggling little mistake. So I don't give it to them in writing when I'm reading it. I give them copies of the charge when the exhibits go back. And my practice has sort of varied over the years. I used to just send in one because I want them around the table talking about the instructions, doing it all together. That became cumbersome, so I've now changed it. I usually send in 5 or 6 copies of the charge. If they want more, they can have more. I usually tell them that. But I won't give them, they won't be sitting in the box reading the charge with me. That's not how I do it, and that's the practical reason why I don't do it. I don't want to be backpedaling. I want to give them the best product, both orally and in writing, that I can give them. So if that answers your question, that's how we'll do it. Now, you'll obviously have the draft so you can read along. And I encourage you to point out my errors despite my best efforts. You'll see me up there marking it up as I always do. Maybe tomorrow will be the case that I get it all right. Still trying. All right, what's the next page?
Your Honor, for the Commonwealth, not so much a page, but circumstantial evidence. I know the court has direct and indirect evidence in there at 23. Would the court consider also including circumstantial evidence in that?
What page you on?
Page 23.
Well, this is the plain language version of the circumstantial evidence.
Yes, Your Honor.
I don't have strong feelings about it. If there's some language you want to propose, I have used other language that refers to things as sort of the more old-fashioned language. This is direct evidence. The mailbox postman thing, I've delivered that a number of times. I think this is with a more modern version of that. But if you want to propose some language, I'm not adverse to explaining it.
I'm just objecting to any additional language, and I'll wait and see what they propose. But
All right.
I think this is sufficient.
It just talks about it in terms of direct evidence and indirect as opposed to circumstantial. I mean, it could be as simple as adding in sometimes called circumstantial.
Yes, Your Honor. Could the Commonwealth submit something later today?
Sure, that'd be helpful.
And if they do, which it sounds like, excuse me, I'm going to then add, just to let the court know, an additional language as for inference that hopefully will counter what they're trying to do. But I'm just giving the court a heads up. I don't want to send you something and you would ask.
How about if I just say that is indirect evidence, sometimes called circumstantial evidence, and then you don't have to do anything this weekend. I mean, not this weekend. It feels like it's the weekend. Then you don't have to do anything tonight. I'm going to suggest that, but you can do what you want. Anything else on the instructions?
Not from the Commonwealth.
I really didn't mean to set off well, there's a word that comes to mind, but it wouldn't be judicial, so I won't use it. When I made my comments this morning, about closing arguments. So let me just say, I'm always trying to stay a step ahead of you. It's not easy. And so I did start looking at this issue a couple of days ago. And I'm going to tell you what the cases I came across and sort of where my preliminary thinking is with regard to this. And maybe there isn't an issue. Maybe there is. But let me just tell you, we all know what I'm talking about, right?
Yes.
All right. So I'm going to give you some cites to some cases, and I'm going to tell you preliminarily where I think the line drawing is. And it's really preliminary because I looked at Tuesday, December 9th. So I guess it was just yesterday. Well, no, that's not exactly when I looked at them. I think I looked at them this week and I sent them to my law clerk on Tuesday, December 9th, or vice versa. So anyway, here are the cases that I want you to take a look at. 2019, Commonwealth versus Ahern, 96 Mass App Court, 197. And that cites to Commonwealth versus Nelson, 468 Mass 1, a 2014 case from the SJC. And I also want you looking at Commonwealth versus Tavares, 27 Mass Appellate Court, 637. And in those cases, the SJC and or the appeals court is really talking about this issue of improper burden shifting and avoiding that in closing arguments. And really, it seems to me the one that's the closest to this is a combination of Ahern and Nelson. And look at those cases. I'm not going to get into a detailed description of what I think the similarities are to those cases. You're going to see it when you read those cases. But it seems to me preliminarily that while the Commonwealth should not comment that the defendant didn't testify, that would be improper. It seems to me that they could point out that there's no evidence that Anna died of any natural causes. I read the pleadings that just came through. And if that is where the line is drawn, you don't have to respond to this right now. I'm not, and frankly, the pleadings that just came through, I mean literally the ones that came through before the defense filed right before I went on the bench. I'm not sure, or the allegations of reneging on a promise are impacted. But I'll qualify that by saying I read the pleading quickly and thought to myself, well, I didn't mean to start that. Back to how I opened this discussion. So that's where I think the line is drawn by those cases. And knowing that's where I sort of am drawing the line, take a look at those cases and we'll discuss it again before the before the closing arguments.
Thank you, Your Honor.
Just to be clear, I think and we'll read the cases, but what the court's saying is that you would think the Commonwealth could comment that something about
That there is no evidence that Anna Walshe died of natural causes.
and of course the defendant can make I just want to be clear about this because I think we might reach some common ground here.
That's what I'm trying to achieve.
And I'm responding to something that the Commonwealth represented, I'm not going to go into right now. So let's just stick to this, if we may. So if the government's allowed to say what
I just said.
And of course, the defendant can argue there's no evidence that there was any homicide or any.
I expect you're going to.
I certainly, or I shouldn't be here, I suppose. But I can, once again, recite the evidence of sudden unexpected death that came into evidence.
That's a little complicated because there's absolutely none of that ties it to Anna Walshe. There's no testimony before this jury that ties sudden unexpected death to Anna Walshe, is there?
Judge, well, when the court asked me that, my response is the government's case is, using that phrase defense attorneys like to use, it's built on a house of cards suggesting that a homicide occurred without any direct evidence of a homicide. And so another causation of death should be fair game to argue because it's equally consistent. And citing the Eremos and Croft, if you have two equally inconsistent propositions, neither have been proved by reasonable doubt. There is no direct evidence of a homicide. And building on that, we've always said there's no direct evidence that anything that came into evidence, the acts of disposal, the acts of the use of tools, occurred after the death of Ms. Walshe. So why is it that the Commonwealth is allowed to ask the jury to speculate based on their circumstantial evidence? I shouldn't use the word speculate. Reach some conclusion based on nothing more than circumstantial when there's no direct evidence of a homicide. And we can't,
They can met out their burden with that circumstance. The law is clear there. They can met out their burden purely with circumstantial evidence. They can. And their circumstantial evidence with regard to the death, again, are those breadcrumbs and what they're going to argue those breadcrumbs mean from the searches to the evidence retrieved from the bags and other, the other distinctions in the evidence.
all of which, Judge, as we've always argued and we will continue to argue, came after any death. And so the issue is, what is the manner of death? And we now have evidence that from their own medical examiner, that death can occur suddenly, unexpectedly, without injury, and it's up for the jury to decide if they can. What evidence do they have as to manner of death when the real possibility, if not probability, is sudden unexpected death due to natural causes, as Dr. Atkinson testified to, and it's equally inconsistent with a homicide. All we're saying is they don't have any direct evidence of homicide. So why do they get to argue it based on their circumstantial evidence when their circumstantial evidence really might only speak to conduct post-death where the death was not a homicide?
But there's evidence in the record before this jury that
I don't want to interrupt the thought process, but there was no objection whatsoever to the entire cross-examination of Dr. Atkinson. So all of that testimony is before the jury. It's not like we represented that, we made some representation that we will present evidence later, and so we made it.
So you can make an argument based on circumstantial evidence. That's what they're going to do in their case. I presume, I don't know what the Commonwealth's going to argue, I presume that they are going to draw a line between some of the evidence that was retrieved from the bags as being circumstantial evidence of things that happened before the dismemberment.
And I agree, they will.
So, for example, the slipper, the blood in the hair. I presume their argument is going to be that before. That's circumstantial evidence, because once the foot covers are purchased, presumably they were purchased, there's a reasonable inference to be drawn, they were purchased to be used. That's evidence of something that happened before.
I think that's an argument.
I think that's an argument to be made based on the circumstantial evidence that's presented. But so I'm turning to you and saying, if you want to argue to the jury that there was circumstantial evidence that Anna Walshe died of some natural causes, I'm just asking, what's the circumstantial evidence upon which you base that argument?
That our argument fundamentally would be that all of the evidence that the government suggests was evidence that was created in the context of a homicide. There is no evidence that it was not created after a death. And so since the jury heard all about the not only just the possibility, but the probability that there is sudden unexpected death, that the jury needs to decide for themselves. Could it have been sudden unexpected death? And all of that evidence that the government is arguing is evidence of a homicide could be only evidence of an attempt to conceal evidence that a person, and using the language and conscience of guilt, a person is acting in a way not out of conscience of guilt, but out of fear or fright or anything of the sort. So why is it that, given the state of this evidence, we can argue our inferences that we believe the jury is allowed to make if they so choose, and if they decide that that evidence of concealment was evidence of a man acting innocently and not with a guilty conscience, then how did Anna Walshe die? Maybe she died a sudden, unexpected death, and he tried to conceal it out of fear or fright, as is contained in the language of the conscience of guilt. And so the jury gets to decide. And it certainly, the thrust of that argument is that it raises a reasonable doubt. And that's the evidence the jury heard.
Your Honor?
Listen, they may not want, I'm not precluding you from making that argument right now. And in fact, they probably want you to make that argument. I'll hear from the Commonwealth.
Sorry for interrupting, Your Honor. Your Honor, this started out with a motion that the Commonwealth not make any reference in closing to representations by counsel in opening statement. The Commonwealth does not intend to burden shift. The Commonwealth does not intend to refer to matters not in evidence. There certainly was testimony from the medical examiner talking about different ways people can die. The Commonwealth is certainly entitled to comment on that testimony, which is in evidence, but the Commonwealth is not going to comment on the opening statement.
All right.
And that's why I was thinking we might find common ground here.
Sounds like we have.
Pardon?
Sounds like we have.
So as long as we're able to argue that a possible manner of death was sudden unexpected death, I understand that the government's going to stand up and say nonsense. And we're going to say homicide, nonsense. Have we found common ground?
I think we have.
I think we're close.
Just keep talking. I don't need to be part of this conversation. I've directed you to the cases why I think they could say something short of commenting on your opening statement. And I've told you what I think they could say. And just be talking to one another
Thank you, Your Honor.
so that there's no surprises.
There's always.
That's true.
All right. And again, I did not mean to create a whirlwind of activity by my comments. I just think that the idea that they couldn't comment at all about the state of the evidence, I didn't want to leave it there. And maybe the takeaway is I should stop thinking about these things 3 or 4 days before they're going to happen. But you have the cases now, all right? Take a word to me. I don't think that there's going to be any edits or changes to it. Again, I'll finalize that at the very end, so you'll have plenty of time between now and then to look at it. How long are the parties thinking they're going to need for closing arguments?
No more than 45 minutes.
All right.
That sounds good, Your Honor.
So 45 it is. I won't cut you off in a case like this, of course. I have cut off in other cases when it's a 2-day case and we're on 45 in this case. And, but just, I know you'll all have a ton of experience, but 45 minutes is about as much as they can take effectively, in my view. So let's try to keep it to that. Well, we will be getting them fresh in the morning, which is good. As opposed to having, a couple hours of evidence in the bank and they're already tired. That's all I have on my agenda. Anything that you need?
Your Honor, would the parties have an opportunity to see the next draft of the court's instructions?
Yes. So I will be going back and editing as consistent with what we discussed. And I will then create a new draft and I'll to you this afternoon.
Thank you.
And if I know that maybe there's some other language you want, I'll consider putting that in the morning. So maybe 8:45 tomorrow so that when the jury comes in, we don't have a big delay if we need to make any changes. And I think that's it. All right. Thank you. One other thing that I want to say is that you can be seated. I very much appreciate the work that you've done in the case to get the case in and tried efficiently on both sides. You picked what you needed to pick as your positions, and I appreciate the professionalism that you've shown on both sides in working with each other. And as I say, I drop into Norfolk County every once in a while as I drop into other counties. You and I, counsel, and I know that this is pretty much the routine of how the courts in the Commonwealth of Massachusetts operate day to day. There's nothing unusual about this case. The level at which you perform is the level at which I see when I travel county to county. And I appreciate the work that you've done on this case and will continue to do on this case.
Thank you.
Thank you.
All rise.
Matters continue.
Our reporter Keith Collins joins us now live from the scene of the bullshit through the use of expensive technology. Good to be with you again, Keith. We have a colorful graphic here that shows instances of bullshit like this are on the rise. Is that right?
Yes, although why is unclear. Some say it's because of one fucking reason. Others say it's because of some other fuck. I talked to this random expert on the subject who told me this thing you're about to hear him say right after he points at a piece of paper.
Obviously, a lot of opinions there to make this story seem somewhat meaningful.
Oh, absolutely, Glenn. This bullshit has some broader implications. Here's a list of tips on how to avoid bullshit happening to you.
And our reporter Keith Collins joins us now live from the scene of the bullshit through the use of expensive tech.
Pretty good. Should I just jump into last Friday? Should I just do that? Everybody who watched that, which was another Norfolk cluster, trying to figure out who could look at it, who can't stream it. It's crazy. Anyway, you guys appear, and you're there to talk about, we hope, something of substance in the Aidan Carney matter with these two pending charges that still are hanging out there for witness intimidation. New judge. Give me your visceral reaction to him. I don't know if you've had history with him or not, but what do you think about Judge BZ?
No history, just, not a Massachusetts lawyer. So, but like anyone else, you put feelers out, you ask the Massachusetts people, what do you know about this guy? And all feedback was good, to be honest with you. It was very, very good. And I think that was borne out in the proceeding. I thought he was efficient. I thought he ran a good proceeding. He put the conflicts issues out there front and center, and I had an agenda. It was clear. I have no complaints, and I think it's just good that we have a judge as opposed to the problem we've had in this case. It's a complex case. There's just so much going on. It just gets shuffled every couple of months, and it's really hard to keep up. And, we have a judge. It's fine. And, we get to go to Boston instead of Dedham, so that's a win, too.
I have to tell you, people have been saying that Michael and I, we were kind of fighting a little bit on the show. We were fighting. We never fought.
We had a healthy disagreement. It's all right.
I was of the view that this was a good move. And, of course, I love Boston juries. I love Suffolk County juries. And I thought that jury, a Boston jury, they get it. They get things really good. And so I was really happy with the way things turned out. My cohort here, who I love and adore as my co-host, even though he is, having feelers out to replace me because I've been gone so long, it wasn't so happy with it.
Yeah, Mark, did you get my note about that? Oh,
no. Oh, you didn't like the way it went?
No. We were just talking about, we're giving her a hard time because she was busy last week, and so I may have talked to a number of people about filling in. Anyway, go ahead.
No, look, there's no complaints. It's fine. He also did what we wanted, which was to bifurcate the conflict issue from all of the other issues, which, at the last discussion about this, which was in front of a different judge involving a whole number of issues, including Karen Reed's cell phones, that whole fiasco. The answer at that time was just, we're going to do everything on December 5th. And then, in between then and then, what happened? A new judge was assigned. They didn't file their motions on time, so the date had to get changed into a status conference, and we got the bifurcated proceeding out of it. So I think that's actually a good sign that everyone agrees and recognizes that if there's a conflict, we shouldn't be talking about the guy with the conflict writing motions to dismiss cases in which he, our view is has no right prosecuting in the first instance. So yeah, no, we're happy.
Even if he does write them in the royal we, in terms of looking at his papers. But with regard to that, I thought it was interesting that he said, well, if you conflict me out, Judge, there's no reason for me to be the other cases. Now, me being Italian and being a little bit suspicious of things, I'm thinking to myself, well, yeah, you don't really want to try anything where, you may be able to try to stack the evidence, or maybe you'll get more money because it will take longer. So I thought that was an interesting comment from Mr. Cosgrove, who, by the way, Michel Bryant has named Cosgrave.
Right. Until he learns how to pronounce Carney's name properly, he doesn't deserve to his properly pronounced.
I thought the comment about if you kick me off the one case, I'm going to quit on the other is actually very interesting and something that we will address in our written response, for the simple reason, why so interested in the case, but no interest at all in the other one, in which there is no conflict, in the 25 window intimidation case. It has nothing to do with the witness at issue. But then again, why the interest in the other one? And is that professional? Is that personal? Is, again, the appearance of all kinds of things? That was a strange comment, I thought, actually.
There was a moment in the hearing, speaking of Cosgrave, when he started talking about some of the discovery and attributed to you some of the material that he had just received, which hopefully will get to you at some point. And I could see there was that moment you were like, you're letting it all play out, but clearly you caught him in this confusion, and it took him a while.
Correct himself. Yeah. He did.
He did finally catch himself. Let me ask you about what you've really gotten and what you haven't. Have you gotten anything since Friday?
No. The check's in the mail. We accept that representation.
Yes.
The mail hasn't arrived yet, apparently, though. So we don't have anything new since Friday. But, the problem that we raised is that, the system, as you know, can't function if you can't rely on the good faith of the prosecution to fulfill its obligations. And again, the court accepts generally, unless there's proof that they haven't complied with, that any representation they make is accurate. And you would hope that's the case. Again, you can't have a civilized criminal justice system if literally you can't trust what the prosecution is saying most of the time. But in this case, we have no clue whether they've complied or will comply with their discovery, because they've said time and time again that they have. Then other stuff shows up. Other stuff shows up on Twitter that we don't have. Other material that is clearly discoverable and in certain cases exculpatory shows up in freedom of information requests that have nothing to do with them fulfilling their discovery obligations in a case like this. And, you saw the other day on Friday, something I've never heard in almost 30 years of this. The now recused / dismissed former special prosecutor has a grand jury exhibit from 2023 that he found and is handing to you in December of 2025. And, I only just got this. The state police were not aware of this, and I was not personally aware of this. And of course, as lawyers, we all understand, legally speaking, that means bupkis. The Commonwealth is the Commonwealth is the Commonwealth. The cops, the DA, the victim witness advocates, the paralegals, they're all the same entity for purposes of possessing evidence, and they're obligated to turn it over. And just the idea that this kind of thing is not being turned over. One of the other things that was referenced, I think you heard the other day, there's allegations and there's testimony to the effect that there are all kinds of harassing messages that are attributed to a certain person, defendant, who allegedly either harassed or had other people on his behalf, or people aligned with him harassed their most important witness in Facebook messages, which were allegedly disclosed to the DA. That's in testimony. The idea that it was actually disclosed. And that testimony would have occurred sometime in 2023. It's now the last month of 2025, and we don't have any of that. If it exists, whether that's truthful testimony or not is part of the problem. That needs to be determined. But in any event, you'd think that a prosecutor would pay more attention to something like that and be concerned about A, why wasn't this disclosed if it's obviously discoverable and important, and B, perhaps more importantly, if it doesn't exist and it wasn't disclosed and there's testimony from their witness under oath saying, I received it and disclosed it, what does that tell you about that testimony? That's troubling for other reasons. And that would be Giglio material, and which is the same thing as Brady material anyway. So we just want what we're entitled to, and frankly have no confidence that they've turned over everything they're supposed to.
Yeah, how could you?
Yeah. Well, going back to Michael's comment here about just the judge, because I do think, you've been very talking good about the judge, and I think he seemed very fair. But I go back to Cosgrove, and when you talk about relying on him, if this man, and I think he pronounced Aiden's name wrong purposely after the judge specifically asked Aiden, how do you pronounce your name, right? And I love judges who do that to both our clients and for us, right? Because how many times do a sign of respect? There you go with the issue of respect. So then he, again, in my view, purposely mispronounces Aiden's name as Kearney rather than Carney. And I think that is a true sign of disrespect, and also how he plans to disrespect him in this proceeding that you have going on, that you can't seem to get your teeth into, because you haven't had a judge that would be fair to the defense. And then we're still sitting out there with Cosgrove and Judge Krupp. So talk about that interplay.
I mean, he's trying to search cell phones that were seized in early 2024, and warrants from January of 2024. Though the probable cause affidavit to seize the warrants but not search them, which is bizarre. That's not how we would do it in New York, for sure.
For sure, Jersey.
They would have gotten the authority to do both. Taint team issues aside, understanding there could be privileged communications and all that. But in any event, they seized these phones in January of 2024. The probable cause affidavit is prepared by Tully, and it's primarily based on two major informants. And this is all public record. I mean, actually, Cosgrove has filed this, and this has been discussed. But one of those two major sources of probable cause for Tully is the witness who is suing Cosgrove and Tully. Okay, she is probably anywhere from, off the top of my head, 8 to 10 large paragraphs of alleged facts which support probable cause to believe that Karen Reed's cell phones would contain evidence of her and Aiden Carney, committing conspiracy to commit witness intimidation, whatever. So they took possession of those phones in January of 2024. They inexplicably never sought a warrant to search the phones when they seized them. Then in March of 2024, Mello went before the grand jury and sought to indict Karen and Aiden together for conspiracy without the phones. So they rushed to get the phones, but they apparently were not so important that they needed to get them for the grand jury. So they ran to the grand jury in March of 2024, which everybody knows returned a no bill, which is extraordinarily rare, particularly where a defendant doesn't testify, and particularly where the two targets are respectively under indictment for murder and witness intimidation. So they didn't do that. So it begs the question, why run out to get the phones, not even seize them, and run to the grand jury? And I think this is where the bad faith comes into play. And, it'll be interesting to see if Karen's legal team, this is more their battle than ours, gets into the bad faith of the request now. It's pretty obvious they ran to the grand jury in March of 2024 because her trial was starting April 1st of 2024. And they didn't want to wait, and it would take time. And they wanted to bang her with an indictment right before her trial. Lots of news, knows, potentially revoke her bail, but either way, get it out in the press that this was going on. I mean, I think it was clearly a rush to indict to gain a kind of dirty advantage in her murder trial. And so nothing happened. The grand jury declined to indict. She goes to trial twice, is acquitted, in my view, twice. And then after the trial, the now new special prosecutor says, well, I think I'll search the phones and demonstrate the existence to commit witness intimidation of witnesses who testified twice at trial that the jury rejected twice. You know, where but Massachusetts would this happen?
Exactly. I know it wouldn't happen in
considering. I mean, that's where we are.
In
You
California.
can't
that
have,
would
to
never
me, you
happen.
can't, yeah, and you can't have any more bad faith to me than you have here. The fly in the ointment is Judge Krupp, who signed the original search warrant for the phones, knowing that the trial was coming up. That's what bothers me, because I don't trust the system. Now, I know you guys are very good. I know Aiden's representing so incredibly well by you and Mr. Bradel, but I just don't trust anybody up there. But I think they may have a little bit more of a problem. They're going to be in a bigger, to me, by being in Boston, with the Boston press and the Boston media, now this is going to be, to me, a bigger story. I don't know if you feel that way, but I think now that you're going to be located there, they may even pick up the story even more than they have.
I mean, I do, in the sense that Boston's the big city and the media outlets, it's just natural that, I mean, look, generally speaking, cases in Manhattan get more coverage than cases in Brooklyn, and cases in Brooklyn generally get more coverage than cases in Queens, and cases in Queens get more coverage than cases in Staten Island, and so on. I mean, when you go to the city, you're going to get more. I mean, we're only going to be there necessarily for one or two appearances, depending on where the judge ultimately ends up. I mean, I have no doubt we're going to end up back in Dedham at some point, but I do think that these oral arguments on kind of the juicy issues that have to be litigated being in Boston, yeah, I think that's a good thing. And I mean, frankly, I just prefer the big city anyway. That's kind of culturally the type of courthouse, the type of environment that I'm more comfortable in than the, like going out deep into the suburbs. Not that Norfolk is that deep into the suburbs, but I mean, I just much prefer the center city and that environment. I think that's better for us.
There's something that something you said there suggests that you're realistically facing what might happen in the recusal and motions to dismiss. No matter how well you've prepared them, documented them, the odds of winning, in my opinion, either of them is difficult. And so you're looking down the road. Would you agree with that?
Well, I mean, you always have to. I mean, you can't assume that motions get granted. I mean, it's interesting because, in the Twitter universe and Twitter law school, everybody judges every argument, every motion, every statement, every comment as this be all end all huge win or a huge loss. And what a big deal one way or the other it is. And of course, in the real world, that's not how lawyers operate. I mean, you have a long game strategy. You realize that there are skirmishes. Sometimes there are battles. Sometimes there may even be major wars before you get to the big one. And, some issues are bigger than others, but it's not all eggs in basket. Everything goes down. I mean, there is clearly a long-term strategy. And in the event, you don't win this, what are you going to do? Of course, that's all thought out, planned, and in the process of being planned. Look, for us, the motion to dismiss is fascinating, but it's one that never should even be revisited in any event, because we believe the conflict is, it's off the charts for a number of reasons. And the public confidence in this prosecution, which already is probably pretty low, the idea that it could continue with a prosecutor and lead detective being sued by someone whose name is going to come up, who could be a witness for either side in this matter, when you already have a situation where the DA's office itself had to be recused because of a conflict. The first special prosecutor had to be kicked off because of making himself a witness, having another form of conflict. And now you go to this. You have the state police that are involved. They have an egregious conflict. They should have.
Hey, I hate to interrupt Mark Betterow. Sorry, sir. Welcome to the lunchtime lawyering thing. It's a little early today. Today's been as short-circuited as it, we queue up in the courtroom just before 9, and the first things we're hearing about are what is not going to happen, right? Let me double-check my audio hookup here just because I forgot to, and I always do. Actually, it's hooked up right. You know how that is. When you check on something, it's always wrong. When you forget to check on something, it's right. Anyway, so we learned that all the things that the court had been preparing for today in terms of Mr. Brian Walsh's testimony and some of the very specific issues related to that were moot, gone, not a big deal. The judge was not happy about that. Hard to tell. Some would interpret her reaction as, kind of unhappy. I'm not so sure I would put it that way. I did want to play just a little bit of from today when the court had to do what the court does when a defendant is going to decide whether or not to testify, and that is make sure it's knowing, voluntary, intelligently made the decision one way or the other. So let me see if I can bring that up. And it is a little trickier here. I don't have my separate screen as I would have when I'm back in the home studio. But let me just play a touch of this for you. And please let me know if you're assuming you're going to be hearing.
Mr. Walsh, if you could stand and raise your right hand, please. Do you solemnly swear or affirm the testimony you shall give in the cause now in hearing to be the truth, and that you shall give all true answers to all questions as put to you by the court in the cause now in hearing? So help you God.
I do.
Thank you.
Excuse me.
You can be seated. I just didn't, was wondering if you were asking me if I wanted him over on the witness stand. I do not.
So this is really the only opportunity to hear him speak other than through the interviews with the cops. And I see your note there, Diz, about the lesser includeds or the lack thereof. It's very interesting how this is playing out.
One important decision that all defendants in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine, the right to ask you questions. If you do not testify, you and your attorney request me to do so, during my final instructions to the jury in the law on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify. First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own words, what are we discussing?
Whether I'll testify or not in my trial.
Right? Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to testify on your own behalf?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Does any party wish me to ask any further questions before I make my findings?
No, Your Honor.
No, Your Honor.
All right. So basically, I got to go. Hold on. I got to go to my other tab here. Stop this. Thank you so much. Anyway, so, prior to the actual back and forth and the colloquy to make sure he was knowingly, intentionally, willfully, intelligently deciding not to testify, the court was advised by Larry Tipton, his defense attorney, no, not going to testify. The judges stayed up very late, whatever that means, working on a number of issues that were going to arise if he were to testify. So there was a hint of maybe, thanks for nothing, pal, since I stayed up working on this stuff. But she's very gracious about that, even though there might be an edge, a tinge of, annoyance. She said, well, it was good to learn about some of those things I hadn't researched in a while. So, and then that still left the question in the morning. You heard when Larry Tipton said, not only is the defendant not testifying, but we don't have any witnesses. But it had to be official on the record as a part of the process. And of course, that was the next thing that was asked and answered is, do you have any other witnesses that you intend to call? And he said, no, the defense rests. I thought perhaps only because she seemed a little tidier, little better dressed today. I thought maybe mommy, Diana Walshe, who held the door open for me when I left the court just now. It was great. She holds no grudge. That maybe she was going to testify. But obviously that possibility came and went very quickly. The defense rested. So then I'm thinking, oh, this is great. They'll clean up with the jury instructions, and then we'll have closings, this afternoon. Perfect. No, that's happening tomorrow. So nothing left today. They're done. Everybody's done. Jury might have been a little annoyed. They get all gussied up. They come in, they sit in their chairs. I mean, it took them longer to enter the courtroom, do the serpentine walk through the jury box. I've mentioned before how that's set up. It's not like you can scatter and the back row can go right to the back row. No, everybody has to walk the S shape that gets them up and into their back row. Hey, we're starting off with another siren. Where are they? Anyway, it took them that walk and get to their seats than to actually sit in court and hear what was going to happen today, which, of course, for their purposes was nothing. So they get the closings tomorrow. We just heard at the end of the session that roughly 45 minutes per side. The judge said, I'm not going to yank you off your feet if you go a touch beyond that. I don't expect that to happen. And I think most people would agree. Each of them spent about half that time on their openings. It does lead to some interesting questions that they brought up. Some of them are pro forma, but, we always talk about how you listen to an opening statement, and I would encourage you, and maybe we'll even run a touch of them tonight when we do our normal show. Listen to the opening statement when you get to the end of the case and see what the parties promised and what they came through with. Well, there's a big thing hanging out there that the defense promised in the opening statement that didn't happen, and that was the testimony of Bryant Walshe. So what is the jury going to do with that? I think he's going to incorporate that into his closing argument tomorrow. And it relates to some other questions that came up today about consciousness of guilt and prior bad acts, some of the things that they can and can't talk about and where they can go. I think it's going to be very interesting. It's going to involve some craftsmanship on the part of Larry Tipton to make sure that he doesn't cross some lines and yet still gets the jury thinking in his direction. So let me look at, I'm just going to go over a few of these tidbits that we picked up today. Then I'm going to hit the road. We'll do the show from back home tonight. I will not be here for the closings tomorrow. Just cannot work that into the schedule. Got to actually do some work. So interesting, I thought, was the discussion they had on whether or not they could talk about the plea deals in the two other charges. I'm not talking about lesser included. We'll get to that. And if I forget about that, Dizzy, send me a note and remind me. Maybe I'll get to that next so I don't forget. But the question was whether or not they could tell this jury that he had pled guilty to the disinterment and lying to the cops. Now, on its face, you might think, well, the defense doesn't want that in because it shows that he's done things wrong. And if he did those things wrong, including again, it's called the disinterment, but it's really the disposal, the movement, the disposal of the body. The code calls it disinterment. Well, if he's done those things, how quantum of a leap is it to say that he killed her, right? But that's not how this played out. The Commonwealth does not want those guilty pleas discussed, and they didn't allow it during the course of any of the evidence because there is the possibility, and I guess if I were a shrink, I would say, well, yeah, I guess that's possible, that the jury would somehow feel sympathy toward the defendant and feel like, well, he's already getting punished. He's already pled guilty to a couple of charges. We're not going to pile on. Let's just let it be. I don't think that that's the normal initial reaction to something like that. Maybe it is, but that's why the Commonwealth does not want that discussed, and it will not be discussed in closings, and it was not discussed through any of the witnesses during the course of the trial. Let's see. Oh, okay. Lesser included. We talked about this all along because as the case was unfolding, and LKB and I have talked about it, and we've talked about it at the lunchtime lawyer thing, everything I heard led me to believe this was a heat of passion, second-degree murder, perhaps voluntary manslaughter scenario where they had a fight the evening of the New Year's Eve party. I keep calling it a party. It was really just and the two of them and a kid that came down and visited for a while. A joyful evening from what we've heard. What was it, though, that triggered the murder if it was not an unexplained sudden death? And we'll talk about how important that's going to be in the closing arguments. Who's going to be talking about that issue, obviously the defense, but what guardrails have been set up. Seems to me it's a heat of passion situation. Maybe it came up that he knew something about Fastow, the boyfriend in D.C. Maybe she brought it up because she had said before to Fastow that, hey, if he's going to learn about it, I don't want it to be by somebody else and a surprise. I'm going to fess up. Maybe she did that night after, all of the glad tidings and, the notes on the champagne bottle box, making it seem like everything's great. The three of us are here, looking forward to a 2023. Clearly, in my mind, something happened that was not anticipated. And that led to her death. That's to me the most logical conclusion, but we don't know. And that brings the defense to their most, strongest point. We don't know. The prosecution is going to argue that as a result of, the court kept calling these things breadcrumbs, as a result of the breadcrumbs that were left, and that's the cleanup operation, the possibility that he knew about the boyfriend or maybe did and didn't care. All of those little things can lead the jury to infer, and they have the right to do that, to infer that he killed her, and that everything else that happened after the fact, the whole mop-up operation, cleanup on aisle 5, that was just consciousness of guilt for the murder and an attempt not to be caught. That's going to be their argument. I still think, had they had the opportunity, the defense, to minimize the charge with a lesser, like second degree, that the jury might have bid on that because of the absence of there's clearly no direct evidence, but not even great circumstantial breadcrumb evidence that would get you to a guilty verdict. I think there are ways they will get there. I think they're going to get there because that's what they want to get to. But on a strict analysis of the evidence, it's thin. It's very thin on intent. And now, and this is something Linda was quick to point out yesterday, now that we have this instability issue, that maybe Brian Walshe was so depressed, he had mental issues, and that could be a mitigating factor in the jury's mind in terms of his intent and any motive to kill her, that he was a little disturbed. All of those things are going to become a factor. I can't wait to see how Larry Tipton, and he is doing the closing, how he works all of that into his argument to make sure the jury focuses on what the Commonwealth has to prove and not shifting the burden to the defense to prove that it was not murder. And they have no obligation to do that. And I posted that in an X post this morning that the court made it very clear to the jury before they were released that the defendant has no burden to come forward to testify, present a case. They don't have to do a thing. And the jury just heard them rest. So they effectively weren't doing a thing except through cross-examination. And it is always the Commonwealth with the burden. That never changes. So she reinforced to them the importance of keeping the burden on the right party and not holding against the defendant the fact that they did not put on a case and that the defendant did not testify. And then they were sent on their way. So the lesser includeds are not there. And how that plays out, I don't know. Some would suggest don't give the jury that opportunity for a compromised verdict that would lead to some level of guilt on a lesser charge. It's a do or die, it's all or nothing on intentional homicide. Here in Massachusetts, it's really the difference is you're either going to get out of jail with the possibility of parole on a lesser, or you're never getting out. So what they're gambling is his ability to be paroled at some point. Maybe when you consider that's the risk of the role, you have less concern about it. You're willing to just go in all or nothing on the murder because you still got these other charges which hold 20 to 30 years in terms of prison sentence. That's a win. A win is just getting sentenced on the 2 that he's pled guilty to. And we'll see how that plays out. I keep wondering about the Friday verdict challenge, right? We're in the holiday season. The jury's got to be ecstatic that the court's prediction last Friday that it was going to be 2 more weeks has been chopped more than in half. And now they just, they're going to get done, maybe Monday if they want to sit, take a breath. But they're going to get the case pretty early tomorrow. They'll be instructed. They'll hear closings. That can all be done before noon if they truly start right at 9 o'clock and there aren't any pop-up issues. But it sounds like the instructions are ironed out to the dismay of each side on some of the different issues. We'll talk about a couple of them here in the time we spend for the lawyer lunch before I hit the road. What should I have for today? Should I grab some local food as I hit the road? Difficult challenges, tough questions. So they'll have plenty of time tomorrow to come to a decision. They do have to get rid of the alternates. We know that's a process that'll happen. And they could clearly come back with a decision tomorrow, kind of a holiday Friday decision. Or they could wait and say, we've kicked it around. Let's sleep on it over the weekend and come back. Either of those things I think are distinct possibilities. Okay, so a couple of the very important instructions, and as I always say, instructions are the most important part of the process, not the most theatrical, but what leads to more appeals and overturned convictions than anything else? Bad jury instructions. And there was an interesting point where the judge today was saying, she almost stopped what she was doing to say, look, I've been on the bench now since 2017. My goal is to get this right, this part of the process, but I don't always get it right. There's always some sort of niggling little issue. And my ears perked up because Linda K. Baden gave me a hard time when I used that adjective before. And here it is. I've been vindicated. I rest my case. Niggling is a legitimate word. It's not a racist term. It means just some little thing that's nudging you. It's niggling. Anyway, so the judge has that issue and is honest about how she tries to get it right and probably has, good a chance as any this time, but maybe making a mistake. She just threw that out there. And I think she probably did make a mistake, to be honest, in a couple of different things that I want to talk about here. As for what the parties can tell this jury, this is not a pure instruction conference issue, but it's important. The defense wanted the Commonwealth to be instructed before the closings that they could not mention the failure of the defense to provide what they promised in their opening. Remember, one of the first things he said was, "You'll hear from Brian Walshe, blah blah blah. Here's what happened." Well, they didn't. In some jurisdictions, it's fair game to say, "Hey, you heard this guy tell you that the client was going to testify. That didn't happen, did it?" That in itself is probably not going to be allowed in any jurisdiction because you can't comment on a defendant's decision not to testify. But if they also said you were going to hear from experts that were going to tell you about sudden unexplained death. They didn't bring anybody to tell you that. They aren't going to be allowed to do that. You can't comment here on anything that was added by the party, either side, in their opening statement. So that's out. They wanted to change, the defense wanted to change to the premeditation charge. That is not going to be changed. We don't have the benefit of having the packet of instructions that they were talking about. So just kind of speculating as to where they were going with that. Oh, I'm reading my my instrument cluster here, which I think says we're gonna lose power in about 20 seconds. I think that's what it says. Let me see if I can fix that. Try and do this. Let's see, what's it say? No, it says it's gonna. Oh, I have to hit a button. Hold on, I'm hitting a button here. I'm hitting a button. Oh, I hit a button. Is it gonna work? Well, we'll know if I disappear. It didn't work. If I don't disappear, it worked. It's like I'm in a spaceship here. I had to hit a button to override. I know. Okay. Anyway, this was another, I think, a very important instruction the defense wanted fixed, and I think the fact that they decided not to fix it, the court said they wouldn't fix this, is an issue. Here's the deal. There is reference on page 9 of the instructions. Get your instructions out. Page 9, there was reference to a weapon being used in this case. And the defense is saying, well, where's the evidence of a weapon being used, or a weapon of any kind? I guess you could argue, obviously, that a knife is a weapon. That they all have other purposes, but knife has a weapon. Saw could be a weapon. The hammer could be a weapon. But the defense point was, where in the evidence is it suggested? Because there's no cause of death, right? There's really even no official cause of dismemberment. There's just some stray pieces of blood evidence and some unknown tissue evidence. It's very vague. And I think by using the word weapon, the jury is being allowed to infer that, well, I guess one of those was a weapon, or maybe all of them were. I don't know. And I think that's inappropriate. I think that's leading the jury to some conclusion they may not really may not get to on their own without that instruction. No, I will not stay around for the verdict. I wish I could, but I can only move so many life matters to do what we're trying to do here, as both Linda and I work full time, obviously. So I will not be here. I do believe, let me correct that. If it doesn't happen tomorrow, I may be able to, because I was going to come up next week, depending on how the case was unfolding. I could come back if they are still deliberating. That's a possibility. So I won't say no, I won't. I just won't be here tomorrow if it happens tomorrow. That would be the thing. Yeah. Let's see. It was kind of, Sheila, it was kind of like, really? I mean, it was just very blank looks on their faces. It certainly wasn't like, great, thank God I'm getting out of here. It was, and there was a little of, looking to one side or the other to their fellow jurors. I just think it was probably a surprise, number one. And to be honest, I think if the court knew this was in the offing, the court might have made an accommodation tomorrow for the jury. Obviously, they still have to come in, but maybe have them come in at 10 instead of getting up early and coming in. And maybe suggested they weren't going to be there all day. Just give them some sort of vague guidance. But the court wasn't able to do that because these issues, including the testimony pending of Brian Walshe, was still up in the air. And not till this morning did the court know that. And how could the court advise the jury? So they were just kind of, I think, numb about it. Like surprised, not happy, not sad, just matter of fact. Yeah, nobody burst into tears or applause. Okay, so the weapon, I think, is an issue that it could cause some problems on appeal. And that's where she began with the whole breadcrumbs analogy. There's breadcrumbs. There's some breadcrumbs. They're there. The defense wanted a sentence added. And this has been submitted to the court. Court's going to kick it around, and I think this helps the court. A sentence that says the jury is not to speculate on whether any of these items were used as a weapon. I think that might be curative, and that might keep an appellate court happy. So then we got to number 15, impeachment. An impeachment instruction. And so the questions became, this got kind of wacky, and it ultimately was dropped from the instructions. But there was no real impeachment. Remember, we get used to impeachment. I mean, look at the Karen Reed trial in this courtroom right here behind me. Impeachment every day, lying to the grand jury, lying in prior statements to the FBI. I mean, that is classic traditional impeachment. Here, the closest we got to that was when Jem Mutlu was uncertain about what he'd said in his first interview with the cops back in January of 2023 about what he knew of the affair and what he knew or thought that Brian Walshe might understand about it. He couldn't make it up. Back and forth on that a number of times until he finally just said, I can't remember her exact words. That was not impeachment. That was an attempt to, in one case, refresh his recollection. Here's your statement. Does that refresh your recollection? Nope. So there was no impeachment. So that one is out. Then they came to the discussion of prior bad acts. And if you think about it, we talked about this all along. Everything that relates to the disposal of the body happened after the fact. How could you use that to create either motive or intent, only crime charged? I think it's difficult. The court went back to the breadcrumbs analysis and said, nope, there's enough there. There's enough breadcrumbs. We're putting that in about prior bad acts. There was some discussion about whether it related to the art fraud or, in a bizarre way, using the disposal of the body and the attempts to conceal that, not as a prior bad act, but as consciousness of guilt, which is also a huge issue for this jury. They could look at those attempts to conceal the body, and they did change the wording on one of the instructions, so it doesn't say conceal the disposal of the body. It says conceal the body, and I do think that's more appropriate. So the question still is kind of weird in this character assassination. I mean, consciousness of guilt based on what was done after the fact. Can that get the jury to find guilt on the charge that requires intent to murder? Let's see. And then I think this is another problem for the court. There was an issue about what the jury can consider, and they will be told they can only consider the murder charge. That's the way it's going to be phrased. You can only consider the murder charge. No other charges can be considered. But then the court's going to list those charges that you can't consider. They're going to list the art fraud, February 2018, sentence 2024. They're going to mention lying to the police, the one he's pled guilty to, disposal of the body, which is the disinterment charge, which he's pled guilty to, and lying to his federal probation officer. So those four things are going to be bullet pointed for this jury and then told not to consider them. I think that might be a problem. I think if you just left it alone and say, hey, there's only one charge pending for you folks, and that is the murder charge, I think you're okay that way. I think you're all right. Let's see. Got rid of the disposal issue. That was good. Yeah. There was a point at which they started talking about the burden shifting, and leading up to it, the court said, yesterday when we talked about this, I didn't mean to set off and then she said a word that I probably can't say here in court. Well, the word was shitstorm. Is that two words or is that hyphenated? I should check on that. Didn't mean to set off a shitstorm when commenting on closing arguments about the burden shifting we talked about off the top. And that is that there is a question about whether the burden has been met by the Commonwealth. Typical question. But in this particular case, it almost creates a burden shifting where the defense has to prove that it was a natural death. And they should never have to prove that. So we talked about this when it happened, when the Commonwealth's expert, Dr. Atkinson, came in, and I immediately said, examination, they have just turned this Commonwealth witness into their bitch. Well, I didn't say that, but turned this Commonwealth witness into their expert on this sudden death, unexpected sudden death. And he goes on and on about it, how it happens. How often? We got like 5 to 10% it happens. And on and on and on he went, supporting the defense position on this. So they've got plenty to argue based on the Commonwealth's expert. And Mr. Tipton pointed out, Your Honor, that nobody objected at any time to any of those questions. Let's see. Oh, Dizzy, thank you. It's one word. Okay. Thank you very much. Shitstorm. One word. Good to know. Let's see. What else? That was really the key. I mean, they wrangled with that quite a bit. And does the defense really have to prove that she died of natural causes? The court even said, well, there's no evidence of that. Well, clearly Atkinson's testimony makes it a possibility, and even a greater possibility than I thought. Now, you may never think it works. Nobody ever buys that. Too bad. But we're talking about the analytics here. In a vacuum, we're talking about theoretically what would these things mean. And I think they did a great job of going through that process. All of this could be out the window when the jury gets a hold of this case and they look at one another and they say, are we kidding? Obviously, this guy did it. They could do that. And there might be one guy. I told the tweeting audience, the Twitter audience, the posting for X audience, there was one guy in the back row, and the door's closing by itself. That tells you how windy it is out there. I have to leave this open or the car thinks that it has to shut off. Truly. And then it shuts off Star Wars and everything else. So you got in the back row, woman, all guys, woman. They bracket the back row. Then in the front row, it's almost the opposite. It's all guys. So the one guy in the back row, when the court was pointing out that it is the burden of the prosecution to prove the case, the defense never has that burden. He was like this. Now, I don't know if he had on some heavy metal and some sort of ear pod thing that we couldn't see, and he was doing some head banging. It was very violent. It wasn't just a subtle. It was like, amen, sister. You got it. And, who knows? He could be an alternate and disappear. But if you have somebody that is very solid in their belief that the prosecution hasn't proved their case, we're talking hung jury. So it can always happen. Don't just say it's never going to happen. We've seen cases many times where the result you expect is the result you get. Short deliberation, 2-3 hours being. Donna Adelson, what was that, 3 hours? About the same as for Charlie Adelson. But you just never know. And let's face it, that's part of the reason that we're invested in these true life stories, not just true crime, true life. So we'll see. We'll see what happens there. Okay, let me take a quick look at these goodies before I close up shop from this location. That's a good question. Thank you, M. Elofs. I know I'm butchering that. It's a clever name, and I'm not getting thing. Can Brian Walshe get a retrial or new trial because there was no defense? No, there's it's a very interesting question. It kind of involves a number of different things. When you waive your right to testify and to put on witnesses in your defense, that's unless he argues Sixth Amendment violation, meaning, and he could, because it happens all the time in appeals, ineffective assistance of counsel. Hey, I was going to put on a case. Hey, I wanted to testify, but these guys screwed up. That would be the one case in which, if successful at appeal, you'd get a retrial. Okay. But that's the only way it would work. There's not anything built into the system that says, well, you didn't put on a defense. Well, let's queue up another trial. Only through ineffective assistance of counsel, if they could convince the appellate court of that. I'm trying to remember. I don't have my my cheat sheet here today, so I'm now I think it was, I want to say 11-5, 11 women, 5 men. That's my gut reaction as I'm looking at the rows. 8 in each row, only one guy in the top row, and mostly guys in the bottom row. It's almost total opposite in terms of the gender mix, top row and front row. So, but it is mostly women. Yes, that is for sure. And mostly women in the, I would say 40 to 50 age range. I might be off a little bit on either end of that scale. Mostly white, a couple of African-American women, and a couple of what I always call non-white, meaning they could be Hispanic, could be Indian, not American Indian, not indigenous, East Indian. But that's about it. I think for this area, probably pretty of the community here. And as I've mentioned in some of my notes, very much more, and this is only week 2. Remember, this is only day 9, and it really wasn't much of a day 9, not counting jury selection. So really only 8 days of evidence. And over that period of time, they definitely got chummier. And this jury, compared to some of the others who are spending many, many really hours alone back in their deliberation room, this jury, not so much. There were some longer sidebars, but they stayed in for that. There were very few like late starts. We had maybe one where they started after 10:15 and the jury had already been told to come in about 9:30. That's the bonding time, right? They can do that on their own. They're not under the microscope. And there wasn't that much here, but I could still tell that there was some, when they'd go to a sidebar on an obvious issue, especially when Jim Mutlew was on yesterday, there were a number of those, issues that, the jury wanted to know more about. In fact, that's what I was asking him as he fled the court yesterday. What led you to believe there were some marital problems? Tell us, what was the deal? None of that came in. It was not allowed. And so there was, every time they went to a sidebar over and over and over again on that, there was a little, especially the front row, I'm guessing 40-ish white guy. Next to him, an African-American woman, probably in same age, be connected somehow. The woman on the top left, African-American woman, older woman, I don't know if I ever saw her take one note. I wouldn't say she was checked out, but she was definitely far less connected to the jury, just in obvious ways. But because it's such a short trial and there was so few opportunities for them to be just killing time in the jury room, it wasn't a deliberation room just yet. I think there's less bonding that way. So, and that can be a factor. That can happen. Okay, let's see. Let's see if I had any other notes before we move along. Just as we were wrapping up, this is not on the record or part of the proceedings, but also something very interesting that you can pick up on when you're in the room. I'd mentioned before, I think I posted a note about Diana Walshe getting with Larry Tipton, and it was clear she was trying to figure out how am I going to get to spend some time with Brian? Because every day he clinks in, he clinks out during all the breaks. They take him down the hallway to a special room that's obviously designed for the defendant and his attorneys. And there's never much more than an acknowledgement of Brian Walshe to his mom, like, kind of a half smile, grimace. And then he shuffles on out, clank, 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 clank. Today, she was asking about actually visiting him just as we were done. And remember, we're now done. The only thing left is the closing arguments. Done with the jury instruction conference. The Larry Tipton and I think also Ms. Porges basically motioned to Diana Walshe that now's the time for a visit. So it appears that after they left, I didn't follow them. She had a minute or two to see her son, have a conversation perhaps. And then I was hanging out for other reasons, came up into the lobby. It's on the second floor, first floor lobby, second floor is other stuff. So I came up from the basement area. She was about ready to leave. So I was probably 5-10 minutes away from the main courtroom, and she was still there. So I'm guessing they gave her that 5-10 minutes to talk with her son. And then, like I said, she held the door open for me when I left. Didn't slam it in my face or anything. And I was surprised to hear when I heard her talk, just sounded to me like an Eastern European accent. I may be totally off, but I hadn't heard a lot of discussion from her before. Certainly she didn't talk to me, but it seemed that it was kind of a middle Eastern European. That's all I got for you. Closings tomorrow. I think the court said 9 o'clock. They shuffled them out so fast. I have to double check my notes on that. But I think it'll be 9 o'clock. They'll have the way she described it was instructions, and then a closing argument, closing arguments, and then more instruction. So we'll see. We'll see what happens tomorrow. And then, of course, there's the appointment of the foreperson and the lottery balls to get rid of the 4 that they no longer need. As it turns out, 4 alts for a trial this short was pretty safe. I couldn't imagine them in 2 weeks losing 4 jurors, but they don't need them now. So those who get the lottery ball, and again, I always believe people disappointed when they put in the time and effort and they don't get to deliberate. It's just annoying. 4 people will get that fate. So, okay, so that's what I've got. We'll maybe talk some more about the jury tonight. Any more thoughts I have on some of their interactions and some of their personalities, from best I could tell, sitting there. But I was basically here for half the trial. It really did end quickly, and very quickly tomorrow. If it's going to be a guilty verdict, it's going to be quick tomorrow. If there's going to be somebody hanging them up, maybe it carries over into the weekend. It is possible. Okay, let me look one last time. Make sure I've got my notes here. This is the first time I think I've used the mobile studio when it hasn't been like snowing or raining outside. It's just, I'm sorry, it's cold and windy. The real feel is 17, 18, and I'm wussed out. I wussed out on it. Sorry, folks. Couldn't do it. So I'm going to head back now to the warm confines of the home studio. So let's see. Oh, the notes. Oh, that's nice. I appreciate that. Where'd that go? Where'd that note go? Where'd it go? It disappeared. Uh-oh, did I disappear? Oh, there it is. Michael, have all the notes sent to Santa so I can get a camper van. Oh, Santa. That would be so sweet. But I don't mind this. This is actually not bad. Yeah, it may look cramped, but it's actually very comfortable. Very comfortable. Thought it was, because I look like I'm riding in the back seat of an Uber. Normally, because I'm on with at least Linda or somebody else, the frame is cut like that, so you don't necessarily see the headrest. You don't see. Yeah, how's your drive today going, bud? How's it going? Yeah, how early did you start Ubering today? Uber small talk. All righty, we'll have some more small talk tonight. Oh, I should mention we were talking yesterday. We did a members only with Mizzy, the Matthew Farwell expert, and Barb, the second cousin of Sandra Birchmore. We did that last night. There was a hearing coming up on the 16th, just next week. In that case, we all pontificated that it's going to push just like everything else has, and maybe it's because they took the death penalty off the table by not asking for the death penalty. Well, that's off. The 16th, it's off. There's been reciprocal discovery, but not to the degree that the state, the feds would like. They've put out a bunch of stuff, they say, but the defense has not provided much of anything in the way of discovery. So there's a new date. I believe it's middle of February. Who knows if that's going to be pushed or not. It looks more like, if compliance starts to happen both ways, they'll probably push that off as well, because they're looking at, potential. When is the trial date? I forgot. I think it's early October. You guys check me on that. So they're plodding along. If there's a deal in the works, they ain't showing their cards. They ain't showing their cards just yet, right? Okay. Oh, and the members only. Obviously, if you were a member, you got to take part and enjoy that. But we'll break it up and throw it out there this weekend for everybody. All right. Yeah, it looks like I'm in a limo. It's very comfortable. Yeah, I'm easy. I'm not a high maintenance dude. Okay, folks. Let's do something later. Let me see if I can end the stream. Can I end the stream? Yeah. Thanks for joining. Again, appreciate it. We'll see you at the top.
Ashes on the sky.